Good afternoon. It's Friday. Yes, a Friday stream. That's what's happening today. It's August 23rd. We knew that Judge Cannoni in Boston was going to rule on this on a Friday. I just didn't think it was going to be this Friday. I thought it was going to be next Friday. But no, it is this Friday. So we are riding for an extra live stream this week because of Judge Cannoni's ruling in the Karen Read case. We're going to cover all 21 pages of that ruling today. It has been something that everyone was waiting for when the judge took this under submission after the August 9th hearing. That August 9th hearing wasn't really a hearing. It was time for oral arguments, and that's what was happening on Friday, August 9th. It was really just for the judge to allow all the attorneys to be heard and make their oral arguments. But that wasn't really something where she was asking questions. It's not something where she was getting into it. It was taking their written motions and then looking at those written motions in more of a argument form. So now that we have the ruling, we have lots, I'm sure, of questions about the ruling. That's why I'm going to go through all 21 pages of it with you so we can get to why the judge denied this ruling, because that was the headline literally everywhere, was this ruling was denied. So we're going to do a road so far after we roll the intro to let everybody catch up with what the defense was arguing and why the judge is taking 21 pages to go through it. But it is what happened. It's what everybody's talking about. So I know a lot of you already know the result of this ruling because it was the headline everywhere. So yes, this ruling was denied. I don't think that's the most important part though, because we knew that was going to happen, right? We knew she was going to deny this. We need to find out not just why it was denied, but what the judge has to say about why it was denied. And that's what we're going to go through today. We knew she was going to deny it. And we'll talk about what's going to happen next. So let's go through all of it. The why is really what matters to me here because the result is what I expected to happen. I don't think there was ever a legal path for the judge to grant this motion. I was hoping that the judge might hear from the jurors, and I'm very interested to see what she has to say about that. So we're going to roll the intro and we're going to get right into it. Chat, it's good to see you. Law nerds, we ride. Hopefully all of you got your app notifications. It's just time to roll. So let's roll the intro, and we've got one topic today, and it's a doozy.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
So I am pulling up chat in my other window because I didn't get it done quite fast enough, but we're going to do a road so far in just a minute. I just want to make sure that I don't accidentally hit this wrong and end up with you hearing me, because that's exactly what's going to happen in just, oh, wait, I can actually fix that. I didn't want that to happen, and I think I can avoid it from happening so y'all don't get an echo, but I want to make sure I have the chat pulled up two ways, which I always do so I can see it better, and that is the thing that helps me the most as I stream. So a little bit behind the scenes as I am still trying to feel a little bit better. We will go over some of the road so far here for just a moment, and then we'll get into this ruling because it is what it is. And I hope that going through the why helps everyone understand. It doesn't mean you have to agree. We are not looking for agreement. We are looking always, when we're parsing down the facts, I am always looking for understanding. Just because you understand something doesn't mean you have to agree with it, doesn't mean that we like the result, right? So let's do a quick road so far, shall we? The Karen Read trial, we watched it together here, gavel to gavel, for 9 weeks with jury selection. It was 10 weeks of trial. At the end of that trial, the jury was unable to reach a unanimous decision, and they told the judge that they were unable to reach a unanimous decision. They were not polled. The judge did not ask. There were no further questions. And I have broken down the judge being like, they said further deliberation would not be helpful. And the judge was like, and I'm not going to ask you to do that. I'm declaring a mistrial. Thank you, ladies and gentlemen. You can go. And it was moments. The jury was in the courtroom. The jury was out of the courtroom. It was like, whoom, bye. But this came on the tail of the jury sending out multiple notes saying that they were unable to reach a unanimous verdict, and the judge giving that much stronger bump to the jury, the Tui Rodriguez instruction, as it is called in Massachusetts, which is a try to reach a decision. No jury is smarter than you are. No one's going to have more information than you do. You might want more to come in, but there is nothing else. You have what you have. Let us know. Go back and try one more time. After the verdict, well, after the mistrial was declared, the defense started getting jurors reaching out to them proactively and saying, hey, here's the confusing thing. We actually reached a verdict on 2 of the counts, and we were stuck on count 2. Like, we reached verdicts on 1 and 3, and we were stuck on count 2, and like nobody asked us, and we don't know what to do with that. Thought somebody should know. After the defense, I should do that better. After the defense got that information, the defense put together a motion to dismiss and affidavits. The defense argument in that motion to dismiss is essentially Karen Reed was acquitted on 2 counts by the jury. So the defense was arguing because the jury in fact reached verdicts, even though they weren't on a verdict form, they're verdicts. And because they're verdicts, she cannot be tried again on counts 1 and 3. Counts 1 and 3 are the counts that require more volitional action, intentional action. Count 1 being that homicide count, count 3 being the hit and run causing death. Both counts require that Karen Reed knew she hit the defendant, or Karen Reed knew she hit the victim. Apologies. And both of those counts require a knowledge element. Some of the lesser included in count 2 get a little different on what requirements there are, and I broke that down all in another episode of the Emily Show podcast if you want a whole discussion of count 2 and lesser included. So the defense was arguing, look, counts 1, counts 3 require volition, but the jury came back and we're being told by multiple jurors that they reached a verdict. Therefore, trying the defendant again is double jeopardy. And or let us talk to the jury, and or dismiss the counts, and or there was no cause for a mistrial, therefore you must dismiss the count. So in their motion to dismiss, there were a number of arguments lined out. Their kind of top level argument was dismiss the case. I think what they were really optimistic for is the judge to allow them to question the jurors about what verdicts were reached. I think the defense wanted this because it allows them to then ask the prosecution to dismiss those counts. Look, the jury came back. The jury had verdicts. Do the right thing. It gives them a stronger arguing position for the prosecution. And it allows the public to know, did all 12 jurors reach that verdict? Or is it a handful of jurors that came forward and other jurors didn't? I think it's telling that other jurors haven't come forward to say, hey, we didn't reach a unanimous verdict. Not a single juror has come forward and said that. So the defense knew this was a bit of a Hail Mary argument for the motion to dismiss, with the argument that this would be a violation of double jeopardy. It is not widely accepted in the law that a juror reaching out after a case saying, but we had a verdict, is a verdict. Generally, there must be a verdict form or a verdict slip, and you have to know from all of the jurors. Most of the case law that allows jurors to be asked about verdicts or asked about anything that happened with the jury after the case is concluded, which is where we're at here, has to do with either outside influence or internal bias in the jury deliberations, but you're generally not allowed to get to the jury deliberations for any other reason. So we've seen jurors be inquired of in the Murdaugh case because the allegation there and the finding there was that there was outside influence, and that is still running up the road to the state Supreme Court in South Carolina. So generally, inquiring of the jurors or polling the jury after a mistrial has been declared is not something that there's really a legal path for. It's not something that comes up. It's something that needs to be dealt with before. This jury's been discharged. They have no more legal bearing on this case. So what the defense was asking for was a bit outside, well, with the motion to dismiss, a lot outside of what case law generally allows for. Though I think there is a strong argument for the defense to ask the jurors if they reached a verdict. We're going to talk about what the judge did here with that in just a minute. I don't think there was ever a path for the judge to just grant this dismissal outright. And I've said that since the beginning. It was my hope that the judge would consider asking the jurors about what they decided and see if all 12 agreed. At the end of the day, we'll talk about what the judge did after we go through this 21 pages, and then I'll answer questions about it. So the judge denied the motion to dismiss. We know that from every single headline everywhere. And we're going to go through why the judge came to that conclusion and break down the arguments that the defense made. Hopefully coming to an understanding of why the judge did this, even if you disagree with why the judge did this. What does this dismissal mean? Well, what does this denial of the motion to dismiss mean? It means that the defense can appeal and the prosecution can go ahead and re-prosecute. This denial basically puts us in the same position that we were before this motion was brought, with a mistrial being granted and the defense having the ability to now appeal this. The defense didn't really have anything else to appeal because there was nothing else to appeal. They were getting a new trial. So they wanted a dismissal, not a new trial, because they've already got a new trial. They want to only go to trial on count 2 versus counts 1 and 3, or 1, 2, and 3. And that makes a lot of sense. So with all of that, we're just going to jump into this motion. Thank you for keeping an open mind. Thank you for not calling names. I know there are a lot of strong feelings about the judge. There are some things I'm going to ask as law nerds that you keep in mind. 1, the jury instructions read by the judge are not written by the judge. They are written by the Judicial Council, and those are modeled after jury instructions elsewhere in the country. The way that Massachusetts has the language on some of those, I find to be confusing, and maybe they will change that going forward. And maybe those jury instructions will be altered by the Judicial Council of Massachusetts, but the judge did not create those. If you don't like the jury instructions and you think they were confusing, that is 100% on the Judicial Council of Massachusetts, not on this judge, even though I know a lot of you don't like her. There was not an easy legal path to this being dismissed. It's not a clear-cut question. And the law was never on the defense's side in this. I think the best possible outcome for the defense was allowing the jurors to voice their opinions. There is nothing that stops all 12 jurors from coming forward. The jurors do not have a gag order. The jurors are not stopped from identifying themselves and speaking up. However, we've seen motions from the jurors in this case that they are nervous about the way the public has behaved. And I understand that. Public vitriol and choosing to step into public vitriol is not an easy thing. And we have seen jurors say, I am concerned if we become public, that we become public targets. And I can understand, given everything I've seen on social media about this case, I can understand why jurors might feel that way, which is why as law nerds, we have rules in our chats and we comport ourselves with, I might disagree with the thing, but I'm not attacking the person. We can attack the logic and the reasoning, and we can talk about that all day long. We stand hard, but when we dislike, we try to go for the position, not the person. And it's what makes this chat so different, but it's what the jurors have watched happen and why they're nervous to come forward. And do you blame them? If their kids are going to get harassed at school, do you blame them for not wanting to put their family through that? If people are going to come into your business, harass you on the street, would you want to identify yourself in that way? I can't say I blame them. I really can't. I love every law nerds. I always love you. I always love you. Today, the amount of you, including Mander, Pander, Salamander, and others who have said very demure, very mindful, very considerate, very considerate. The law nerds are considerate of others. You, again, talking about a position and not a person is the way to have disagreements. So look at us. Very cutesy, very mindful. And I appreciate it because I understand, and I don't fault the jurors for not wanting to willingly stomp on a hornet's nest of shit across social media where people will dox them, harass their employers, harass them, harass their spouses, harass their children. And we've seen that in this case, and I understand why they're concerned. I don't think it's good for justice that the jurors are concerned. I don't think it's good for justice that the jurors were confused. And I don't like the jurors not being heard from. That is my personal opinion. I don't like it. I think the jury and their wishes should be honored. Let's see what the judge did, and then we'll go forward. Look, we can be demure and cursy all at the same time. Emily, that's not what demure means. I don't care. We redefine words here. It's fine. We can be fucking demure if we want to. Very fucking cutesy. We can make curse words demure. It's fine. If there are words to describe EDB, loud has come up much more than demure. We can make anything rhyme. Emily, we're not Eminem. Remind yourself. All right, chat. Let's get into this 21 pages together. She's a long ruling, and I think it's because the judge wanted to explain. Let's see if we can put aside how we feel about the judge and see if we can understand the judge's perspective. Perspective. Let's see if we can reach understanding, even if we don't reach agreement. I'm not asking for agreement. I'm not going to ever tell anyone to agree. Let's see if we can understand. Commonwealth versus Karen Reed, memorandum of decision and order on defendant's motion to dismiss. Before we get into this, hold on. We knew it was coming on a Friday. Chat, you fucking called it. When we heard the Friday motion, y'all called that it was going to be a Friday. All of you said, this shit's going down on a Friday. But all of this is going down on a Friday, and we thought it might be next Friday. It's this Friday. We knew it was going to be a Friday. I have to wonder, is the judge taking next week off? Like, I just need to know, is there vacation next week? We thought this was going to be dropped before a vacation. Maybe the judge just has the whole next week off, so we're not dropping it on the Friday before Labor Day. We're dropping it on the Friday before Labor Day week, and the judge is just taking the whole week off. I just have questions. My guess would be that there is a vacation next week, and this is a bye. That would be my suspicion. All right, let's
bring the jury.
Let's go to court, shall we? Let's see what we have a whole week next week, so maybe it's better that it happened this week because next week we got a whole bunch of shit to do, don't we? Memorandum of decision and order on defendant's motion to dismiss. On June 9th, a Norfolk County grand jury indicted Karen Reed on charges of murder in the second degree, manslaughter while operating under the influence, and leaving the scene of a personal injury and death. That's counts 1, 2, and 3 in that order, following the death of her boyfriend, John O'Keefe, on January 29th, 2022. Trial on the matter began in April 2024. Why does it feel like it was 100,000 years ago that April happened? There were 8 weeks of evidence and nearly 5 days of deliberation after the jurors expressed to the court that they were deadlocked. For a third time, the court declared a mistrial. The defendant now moves, let's see if we can begin this a little bit. The defendant now moves to dismiss the charges. Miguelina, no, I can't highlight. We're trying to figure out why the mouse is not showing up in the right space when we use this particular browser, but no, it won't let me highlight. The defendant now moves to dismiss the charges for murder in the second degree and leaving the scene of a personal injury and death, arguing that retrial would violate the double jeopardy protections of the federal and state constitution because the jury, in fact, reached a unanimous decision to acquit the defendant on those charges. I think that's a really good summary of what the defense is arguing. Alternatively, the defendant argues that dismissal is required because there was no manifest necessity to support the declaration of a mistrial with respect to those charges. Yeah. After careful consideration, this court concludes that because the defendant was not acquitted of any charges and defense counsel consented to the court's declaration of a mistrial, double jeopardy is not implicated by retrial of the defendant. The motion is therefore denied. So this is the summary of what the judge is going to do, and the judge is going to give us 21 pages of like, why did I do it? I appreciate that the front page is very like, this is what's happening. Background. On June 25th, 2024, the jury began its deliberations. It feels like 100 million years ago. It really does. On June 25th, the jury began its deliberations in the defendant's trial. In addition to the 3 indictments, the court had instructed the jury to consider 2 lesser included offenses to manslaughter while operating under the influence of alcohol, involuntary manslaughter, and motor vehicle homicide, OUI, liquor and negligence. That is count 2 and the lesser included, that the judge was talking about. On Friday, June 28th at approximately 12:10, the jury foreperson sent a note to the court. It stated, quote, I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict. The court requested argument from the Commonwealth and the defendant as to whether there had been due and thorough deliberation from the jury. ADA Lally, on behalf of the Commonwealth, argued that the jury had not had sufficient time to deliberate, and therefore it was far too early in the deliberative process to give the Tui-Rodriguez instruction. Footnote 1. The use of the Tui-Rodriguez instruction is a matter of discretion for the trial judge. Commonwealth versus Pereira. Quote, it is the orthodox approach to dealing with the deadlocked jury, see Commonwealth versus Furman, and, quote, designed to urge the jury to reach a verdict by giving more serious consideration to the opposing points of view. The order goes on to say, he also pointed out that although the note indicated the jury had not yet come to a conclusion, it did not indicate that doing so was not possible. Attorney Yannetti, on behalf of the defendant, quote, disagreed with Mr. Lally's characterization of the note. He argued, and this is Yannetti. We went back and watched all of these. The word exhaustive is the word that I think is operative here. The jury is communicating to the court that they've exhausted all manner of compromise, all manner of persuasion, and they're at an impasse. You know, this is a case where the jury has the legal instructions. They've only really asked one question, which was to try and get a report that they're not allowed to get. And I think the message has been received that the evidence is close and they won't get anything more. They've been essentially working nonstop for over the last 3-4 days. We're approaching a weekend. They didn't come back with this at 3 o'clock or 4 o'clock. They're at 12 o'clock and they have nowhere to turn. So our position is that the jury should be read the Tui-Rodriguez model instruction and go from there. We'll call this note number 1. So this is note number 1. And at note number 1, Yannetti was like, they're deadlocked, let's go. They're deadlocked, let's go. Let's go. The court ruled that given the length of the trial, the number of exhibits and witnesses, the complexity of the issues, and that the jury had only been deliberating for 3 days, deliberations had not been sufficiently due and thorough to warrant a Tui-Rodriguez instruction. I instructed the jury to continue deliberating. On Monday, July 1st at approximately 10:45 a.m., the jury sent another note to this court. So note number two. Note number two. The note stated, quote, despite our commitment to the duty entrusted in us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to the point where consensus is unattainable. We recognize the weight of this admission and the implications it holds. So the jury comes back and says, no. They also say in this note, the divergence in our views are not rooted in a lack of understanding. And I think this is kind of instructive here because lack of understanding is saying they understand what they need to do. It's not saying that they're confused. The court again requested argument from counsel as to whether there had been due and thorough deliberations. The Commonwealth argued that the jury had been deliberating 22 or 23 hours, but given the length of the trial and number of exhibits and witnesses and complexity of the issues, that they had not done a thorough deliberation up to this point. Attorney Yannetti again had a vastly different view. He argued, quote, I'm going to pause real quick. Let's side note. We're going to sidebar. Come, bring it in. We're going to sidebar real quick. Bring it in. Here's why the judge is quoting the defense attorney. The reason the judge is quoting Yannetti during this part of her order is because the defense is arguing that the judge did not have their consent to declare a mistrial. And for that reason, the mistrial should not have been declared, and therefore the case must be dismissed. So part of the reason she is quoting the defense is because one of the arguments is that the defense never said a mistrial was or should be declared, and the defense didn't have opportunity to argue. So the reason that she's quoting the defense is I think we're going to get to the point where she's saying, I'm not dismissing this, and I think the defense consented. And we know that she's going to argue that because she put it in page 1. Page 1 was a real good summary. The defense consented to the dismissal, she says, and the jury did not reach a verdict, and therefore it's denied. Those are the 3 things she said in page 1. So let's continue on. That is why she is quoting the defense attorneys in this. So she's quoting Yannetti again saying, let me move this real quick. Hold on. Sorry, we have multiple screens going. We got things we got to keep going, and that's what we're doing. All right. Our view is that, back to Attorney Yannetti. We're trying to keep it together so it's easy to follow. Back to Attorney Yannetti in court after note number 2. Quote, our view is that it is time for a Tui Rodriguez instruction. They have come back twice, indicating essentially that they're hopelessly deadlocked, but the content of this last message is that they have been over all the evidence. The previous message said they did have an exhaustive review. This time, they said that they have fundamental disagreements about what the evidence means. It's a matter of opinion. It's not a matter of lack of understanding. This court, when you sent the jury out, encouraged them not to take a straw vote, encouraged them to go over all the evidence in a very methodical manner, very demure. I think all indications are that they have done that. This is what Tui Rodriguez is for. So the defense again is arguing, Your Honor, they've told us where they're at. They've told us that they're stuck. So the only thing to do is to kind of nudge them to unstick, but I don't know if that's possible. So give them the nudge. The Tui Rodriguez instruction is the nudge. It's a strong nudge, but it's the nudge. Give them the nudge and then see where we go. The order continues saying, the court agreed that the jury had engaged in due and thorough deliberations, noting that this jury had been, quote, extraordinary, and that it had never seen a note like this from a jury. It thereafter provided the jury the full Tui Rodriguez instruction and asked them to return to deliberations with those instructions in mind. Footnote 2. Oh, God. We're not reading. Should we read the entire Tui Rodriguez instruction? I feel like I said we're reading the whole thing. We have to read the whole thing. All right. We're reading the whole thing. Chad is like, no, you don't have to. We're here. They put the entire body of the Tui Rodriguez instruction in the footnote. Okay, let's roll. All right. Sorry if you heard my neck just pop. I was trying to be funny, but then things happened. Okay, footnote 2. The Tui Rodriguez instruction states, quote, our Constitution and laws provide that in a criminal case, the principal method for deciding questions of fact is the verdict of a jury. In most cases, that... I can't speed read. I'm dyslexic. Why am I trying? I don't know. We're going to do it anyway. In most cases, and perhaps strictly speaking, in all cases, absolute certainty cannot be obtained, nor is it expected. The verdict to which each juror agrees must, of course, be his or her own verdict, the result of his or her own convictions, and not merely an acquiescence in the conclusions of other jurors. Still, in order to bring 12 minds to a unanimous result, you must examine the issues you have to decide with candor and with the proper regard and respect for each other's opinions. You should consider that it is desirable that this case be decided. You have been selected in the same manner and from the same source as any other future jury would be selected. There is no reason to suppose that this case will ever be submitted to 12 persons who are more intelligent, more impartial, or more competent to decide it than you are. Or that more or clearer evidence will be produced at another trial. Yeah, more or clearer evidence is never coming. Ladies and gentlemen, all humans of the jury, it's never going to get more clear. On that, we are all agreed. On that we can agree. With all this in mind, it is your duty to decide the case if you can do so conscientiously. In order to make a decision more attainable, the law always imposes the burden of proof on the Commonwealth to establish every essential element of each indictment beyond a reasonable doubt. If you are left with a reasonable doubt as to any element of the indictment, then the defendant is entitled to the benefit of a doubt and must be found not guilty on the indictment. In conferring together, you are to give proper respect to each other's opinions and listen with an open mind to each other's arguments. Where there is disagreement, those jurors who would find the defendant not guilty should consider whether the doubt in their minds is a reasonable one, if it makes no impression on the minds of the other jurors who are equally intelligent, who have heard the same evidence with the same attention, who have had equal desire to arrive at the truth, and who have taken the same oath as jurors. At the same time, those jurors who would find the defendant guilty ought seriously ask themselves whether or not they may not reasonably doubt. Can we reword these? I have some suggestions. Whether they may not reasonably doubt the correctness of their judgment. If it is not shared by other members of the jury, they should ask themselves whether they should distrust the weight or sufficiency of the evidence if it has failed to convince the minds of their fellow jurors beyond a reasonable doubt. That should be the entire footnote. Thank goodness. We made it. Look, Ma, we made it. That's the Tui Rodriguez instruction. That is the jostle that they provide to the jury, the bump, if you will, to say, hey, if you think the defendant's guilty, are you sure you don't have any doubt? And if you think the defendant is not guilty, are you sure your doubt is reasonable? That's the instruction. That same day at approximately 2:30 p.m., the jury sent another note to the court. The court stated to counsel that the jury was at an impasse. That's exactly what the court said. The court came out and said, the jury's at an impasse, bring them in. Like, after the jurors filed into the courtroom, the court read the note. So this was the first time it seems that the defense, the prosecution, and everybody else heard this note. This is note number 3. Quote, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs, which is not what anybody wants the jury to do. No one is asking them to sacrifice deeply held convictions or beliefs. No one is asking them to change their mind as to those deeply held convictions or beliefs. So the judge read that in court. The judge at this point does not dispute what the defense says. The defense said they had no heads up of what the note said, no conversation about what the note said. So this squares with what we have heard. And that was essentially, hey, we didn't know until the judge read it in court. And the judge read that and with a swiftness said, I'm not going to make you do that. I'm declaring a mistrial. That was it. So this was note 3. The order goes on to say, after reading this note, the court declared a mistrial and discharged the jury back to the deliberation room to wait for the judge. Counsel remained in the courtroom to discuss an agreeable date to return for a status conference. On July 8th, the defendant filed the instant motion to dismiss, supported by affidavits from Attorney Yannetti and co-counsel Attorney Jackson. Attorney Jackson's affidavit stated that on July 2nd, a juror in the case, Juror A, contacted him. Attorney Jackson was able to identify the person as a deliberating juror based on their description of who they are, where they were seated, and certain identifying information, name, occupation, disclosed during voir dire. According to Attorney Jackson's affidavit, Juror A told him that they wished to inform him of the true results of the deliberations because they believed those results significantly impacted the defendant's rights. Juror A said the jury unanimously agreed that the defendant was not guilty of counts 1 and 3, and specifically that the murder charge was, quote, off the table. First Jackson affidavit at paragraph 5. In all of these, by the way, I will note that it all says he/she. That's a lot to say, and I think it's easier for me to just say they, because the law is just so burdened with he/she. I'm like, can we just use they in there? It's not hard. Anyway, so in the order, it says he/she. That's what Alan Jackson put. That is what the profession still does. I'm changing it on my own just because it's easier for me to say. I think the jury instructions will start to change because it's easier, but whatever. In this affidavit, Alan Jackson stated, quote, neither Miss Reed nor her counsel consented to the entry of a mistrial. Defense counsel was denied the opportunity to request that the court inquire on which count or counts the jury may have been deadlocked, including lesser included offenses, and on which count or counts the jury may have arrived at a verdict. They did argue that. Attorney Yannetti's affidavit averred that on July 3rd, he received communications from 2 informants. Heard it. I hated these affidavits. Heard it from a friend who. It's just. Attorney Yannetti's, let's see, hold on. Attorney Yannetti's affidavit averred on July 3rd he received communications from 2 informants who had received information from 2 deliberating jurors in the case. The first informant sent him a screenshot they had received from someone else, intermediary B, of text messages that intermediary B had purportedly received from a juror B. It's such a game of telephone. It's person 1 saying that person 2 talked to person 3, and person 3 told person 2, who told person 1, who then told the attorney. Those were a mess. Attorney Yannetti averred that he was able to positively identify which juror was Juror B based on first name given to him from informant B. In the screenshot, Juror B texted intermediary B that went to informant B. It's like B1, B2, B3. Hey, B2, B1, B2, B3. In the screenshot, Juror B texted intermediary B, quote, it was not guilty on second degree and split half for the second charge. When the judge sent us back with that Hernandez thing, it took, Tui Rodriguez, by the way, it took, when the judge sent us back with that Hernandez thing to look at the other side, it turned into a bully match. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even that she hit him on purpose. Yannetti affidavit at paragraph 4. Attorney Yannetti stated that another informant Informant C contacted him on July 3rd. Informant C told him that they personally know Juror C and that Informant C and Jury C have a mutual friend, Intermediary C. Again, 3 people. Person 1 talked to Yannetti, person 2 talked to the juror, and then person 3 is the juror. These were a mess. So Juror C and Informant C have a friend, Intermediary C, who is a coworker of a friend of Jesus Christ, who is a current coworker and friend of Juror C, who is our cousins, boyfriends, sisters, uncles, bestie, college roommates, veterinarian or something. Intermediary C told Informant C via text message that Juror C was a deliberating juror in the case. Intermediary C had a discussion over text message with Juror C about the experience of being a juror. And Intermediary C said that Juror C said that there was, quote, no consideration for murder 2. Manslaughter started polling at 6-6 and ended deadlocked at 4 no, 8 yes from the Yannetti affidavit. These were a mess. Informant C texted back, interesting, if there's no consideration for murder 2, shouldn't she have been acquitted on that count and hung on the remaining charges, or chargers, spelling an original, goes back to the jury slip that was confusing. Footnote 3. As noted below, defense counsel argued that to the court that the verdict slip for indictment 2, which allowed the foreperson to check guilty for the lesser included offenses, would be confusing for the jury if they decided the defendant was not guilty of all the lesser included offenses. Intermediary C texted, she should have been acquitted. I agree. Yes, the remaining charges, what they were hung on, and the instruction paper was very confusing. Attorney Yannetti said that based on the description of Juror C he received from Informant C, who talked through Intermediary C, and the description of what Juror C told Intermediary C, he could positively identify that the juror was a deliberating juror, not a rando, right? Attorney Yannetti later filed a supplemental affidavit in support of the defendant's motion to dismiss, wherein he stated he received an unsolicited phone call from an individual identifying themselves as Juror B. Juror B told Yannetti that they were familiar with the affidavit he had previously filed and confirmed the substance of the conversation between Informant B and Intermediary B. Juror B clarified that they meant to write, no one thought she hit him on purpose or even knew that she hit him. Yannetti's supplemental affidavit. On July 10th, Attorney Jackson submitted a supplemental affidavit stating that on July 8th, another juror, Juror D, contacted him. He identified this person as a juror by the description of who they were, where they were seated, and certain identifying information, name and occupation disclosed during the voir dire process. Juror D told Jackson that they were, quote, uncomfortable with how the trial ended. Can you imagine? Can you imagine how uncomfortable the jurors would be if they're like, wait, I thought we reached a verdict and no one asked us about it? Like, I don't know if uncomfortable is the right word. I think I'd be fucking pissed, right? I really do think I'd be pissed. Like, you're there for 10 weeks. I'd be so mad. So Juror D said that they were uncomfortable with how the trial ended, and Juror D said that it was very troubling that the entire case ended without the jury being asked about each count, especially count 1 and count 3. That is from the supplemental affidavit. According to Jackson's supplemental affidavit, Juror D told him that the jury agreed that the defendant was not guilty on counts 1 and 3, and that they disagreed solely on count 2's lesser offenses, but they believed that they were compelled to come to a resolution on all counts before they could or should report verdicts on any counts. Juror D believed that all jurors would corroborate their account. They also stated that if necessary, they would testify before this court as long as their identity remained protected. On July 18th, Attorney Jackson submitted a second supplemental affidavit. I think that's the third supplemental affidavit, stating that on July 17th, this would be third, he was contacted by another juror, Juror E, who he identified by the description of who they were, where they were seated, and certain identifying information that was disclosed during voir dire. Juror E also stated that the jury was unanimous on counts 1 and 3. and that the defendant was not guilty of those charges and that they were deadlocked on one of the, quote, lower charges on count 2. Jackson's supplemental affidavit. At paragraph 5. On August 1st, the Commonwealth filed a post-trial notice of disclosure stating that ADA Lally had received 2 unsolicited voicemails from an individual identifying themselves as a deliberating juror, stating that the jury had been unanimous on counts 1 and 3. The Commonwealth also received emails from 3 individuals identifying themselves as jurors, stating that they wished to speak anonymously. In its response to the emails, the Commonwealth stated that it was ethically prohibited from inquiring as to the substance of jury deliberations. Again, I have yelled at length about the fact that I don't think asking the result is asking the substance, but you know how I feel about that. The Commonwealth and I aren't going to agree on this. We don't see eye to eye. I don't think that's the substance of deliberations. I think the Commonwealth is really splitting hairs on this one, but they're going to do what they think they have to do, and we're just going to, Emily, we've got to let it go, which is a song well outside of any range I could ever imagine to have. So am I going to sing Let It Go? No, we're going to just let it lie. So the Commonwealth said that they don't think they are ethically prohibited from inquiring as to the substance of the jury deliberations, and they could not promise confidentiality. This I actually agree with. They could not promise confidentiality as it may be required to disclose the substance of any conversation to the defendant or the court. I think it's misleading. I think it leaves out some information, but I also think the Commonwealth cannot promise confidentiality because it might need to be disclosed to the defense and to the court. I think that's fair. All 3 jurors declined to communicate further with the Commonwealth. Gee, I wonder why. The Commonwealth left out some information. I think they could have clarified who they might have to disclose it to. They chose not to do that, but they're like, we can't promise confidentiality. And then the jurors were like, yeah, okay, well, we don't want to talk to you anymore then, right? Is that a surprise to you at all? That when the Commonwealth was like, we can't say you're going to remain anonymous, that the jurors were like, well, and miss me? I'm not surprised. Discussion. The 5th Amendment to the United States Constitution applicable to the states through the 14th Amendment to the United States. Good civics. Good. And Massachusetts common and statutory law protect an individual defendant from being twice placed in jeopardy for the same crime. Yes. True. Paragraph 1, understanding and agreement. Those statements are accurate. I wonder if that's where this will stop. The court then cites a bunch of case law and says, including case law that says, quote, the double jeopardy clause affords the criminal defendant, quote, a valued right to have his trial completed by a particular tribunal. A defendant is entitled to protection from double jeopardy, quote, if there is some event, such as an acquittal, which terminates the original jeopardy. It then goes on to say, or if a mistrial is entered, quote, without the defendant's request or consent, unless there was a manifest necessity for a mistrial. And that's where we're going to get stuck on this, because was there a manifest necessity here to declare a mistrial? I think all of the case law would probably agree there was, in fact, a manifest necessity based on those 3 notes. No appellate court is going to look at those 3 notes and go, no, you didn't need to declare a mistrial. Where you might see a circumstance, and this is an example, this is a hypothetical, where you might see a circumstance where a court or an appellate court would say there was no manifest necessity, is if the jury came out with like, excuse me, Your Honor, we have a question. We'd really like to see the video of the defendant's interview with police again. And then the court said something like, it sounds like you're unable to decide the case. I'm going to declare a mistrial. That would be a circumstance where I think all courts would look at it and go, that was aggressive. You didn't need to go ahead and declare a mistrial there. They just wanted to see a video. So what you should have done is just let them see the video, right? That's a circumstance where I can see an appellate court saying there was no manifest necessity here to declare a mistrial. But when you have 3 notes that indicate that the jury is deadlocked, one of those coming after Artuli Rodriguez, the appellate court is going to look at that and say, yeah, obviously there's manifest necessity for a mistrial. The jury has said as loud as they can, we are unable to reach a decision. None of those notes were confusing. None of those notes were unclear. There was no waffling. All of those notes were, we've tried. And the note said there is no lack of understanding here. The jury told the court, we understand. Now, that is what that is. So I don't think an appellate court is going to look at this and say there was not a manifest necessity. I think they're going to say there was a manifest necessity. So even if the appellate court said the defense didn't acquiesce to this, then I think they're going to find a manifest necessity. I think this prong of the argument is dead in the water, truly. It goes on to say the interest in giving the prosecution one complete opportunity to convict those who have violated the laws justifies treating the jury's inability to reach a verdict as a non-event that does not bar retrial. In her motion to dismiss, the defendant argues that a retrial on indictments 1 and 3 would violate the double jeopardy protections of the federal and state constitution because despite absence of a jury verdict, the jury in fact reached a unanimous verdict. Well, you can see how the judge feels about it. That's pretty clear. The judge says, despite absence of a jury verdict, the judge puts no weight in anything in these affidavits, it seems to me. Despite the absence of a jury verdict, the jury in fact reached a unanimous decision to acquit her on those charges, or alternatively, because there was no manifest necessity to support the declaration of a mistrial with respect to those charges. After careful consideration, the court concludes that the defendant's arguments are without merit. Yeah, you could see that coming from the beginning of the sentence, couldn't you? The court's like, no. Acquittal of the defendant. So the court's going to break down the arguments into 2 parts. This is the one I'm most curious about because the manifest necessity is not their strongest argument. Acquittal of the defendant. The defendant first contends that she was acquitted on indictments 1 and 3 and therefore I'm getting rid of that doesn't need to be there. Grammarly doesn't like it, neither do I. And therefore retrial is barred based on her attorney's affidavits purporting to reflect statements by jurors that the jury reached a unanimous conclusion that she was not guilty on those charges. Look, ma'am, if you don't think that the defense affidavits, when coupled with the fact that individuals reached out to the prosecution and said the same thing, this is me now arguing with the judge. If you think that the purported statements to both sides of a case and at least one statement to the media, if you don't think that those are enough, ask them. The judge is putting absolutely no weight in the affidavits based on this language. This is purported. Okay. Based on her attorney's affidavits purporting to reflect statements by jurors that the jury reached a unanimous conclusion that she was not guilty on those charges. Although all the statements and affidavits are from purported jurors who wish to remain anonymous, for the purpose of this motion, the court accepts the statements as true and accurate. Yeah, your language says that you really feel that way. Sure. Look, I am okay. Accepting them as true and accurate. Footnote 4. While the court accepts the averments as true and accurate, it disagrees with defense counsel's characterization of the statements as, quote, strong and uncontradicted. The substance of the conversations directly contradicts the notes the jury wrote to the court during deliberations, the last of which expresses disagreement over whether the Commonwealth met its burden as to the, quote, elements of the charges, emphasis added. Well, we know how the judge feels about that then. And this is what's so frustrating to me about this. There is room for argument and disagreement over what they mean by charges, because charges can either mean count 2 and its lesser included, or charges can mean counts 1, 2, and 3. So I still think there's room to have that conversation. Then again, the notes didn't say we have reached verdicts on some counts and not others, and we're unsure of what to do. And that's hard because the jury didn't say we've reached verdicts on some counts, but not all, and we don't know what to do. If the jury had said that, we'd be in a much different situation. But how do you fault someone if they don't know what they don't know, or fault a jury? I'm now referring to the jury as a singular, but how do you fault a jury if they don't know what they don't know, especially if they haven't done jury duty before? How would you know what you don't know? It's frustrating to me because, again, I think the jury is going to be frustrated, and I wonder if it has a chilling effect on whether people want to do jury duty or not. They're like, well, even if we reach a verdict, nobody's going to know. So the judge is saying, look, the notes in court contradict what is being said after the fact. That is how the judge is interpreting this, that the judge's take wins on this because, well, that's the judge. We'll see what the appellate court has to say, but that's the judge. I'm sure this will be appealed. So it goes on to say, even doing so, any agreement among the jurors as to counts 1 and 3 cannot be considered acquittals for purposes of double jeopardy. Tell me why? To trigger double jeopardy protection, an acquittal requires a verdict on the facts and merits. Commonwealth versus Brown, which is a Massachusetts Supreme Court case, quote, a person shall not be held to answer on a second indictment or complaint for a crime of which there has been acquitted. I read that so awkwardly. A person shall not be held to answer on a second indictment or complaint for a crime of which he has been acquitted upon facts and merits. And, quote, the only verdict which can be received and regarded as a complete and valid verdict of a jury is an open and public verdict affirmed in open court as the unanimous act of the jury and in presence of the whole panel, so that each juror has an opportunity to express his dissent to the court in case his decision has been mistaken or misrepresented by the foreman or his fellows, or in case he has been forced into acquiescence by improper means. Right. That stands for the fact that the jurors have to be polled. Right. The case law quoted says the reason right. The case law that the judge is citing very clearly delineates that you need to have a jury in open court. Is this your verdict? And then if they don't all nod, then you can ask more questions, or you go seat by seat. Juror number 1, are these your verdicts? Juror number 2, are these your verdicts? And on and on and on. This case law says exactly what I've been saying, which is Open and public affirmed in open court as to the unanimous act in the jury in the presence of the whole panel so that each juror has an opportunity, polling, each juror has an opportunity to express his dissent to the court in case his decision has been mistaken. Here, it seems that the court's mistrial is mistaken. I think this case law allows for questioning of the jury. But then again, I have had cases go to mistrial. I have seen lots of cases go to mistrial. I have never seen a case that goes to mistrial where the jury's not polled. But I don't practice in Massachusetts. So, but even if the jury's polled now, a verdict can't be rendered now. That jury has been dismissed and a mistrial declared. You can't do it after the fact, which is why I said in my coverage of this, as we started, I'm unsure if there is even a path for the judge to dismiss this. Legally, I don't think there is. I think legally there is only a path for the jurors to be questioned and then for the Commonwealth to dismiss the counts. I don't think the judge can dismiss them. I don't. So I've seen some of you say Massachusetts only allows for polling a verdict, not a non-verdict. I have seen that the attorneys can request polling in the case of a mistrial. So the argument then becomes, but none of the attorneys asked. And that's accurate. None of the attorneys asked to have the jury polled. So the appellate court is going to have to sort this out because we know this is going to be appealed, right? The judge knew it was going to be appealed. When the judge granted the oral argument, the judge said, whatever the decision is, it's probably going to be appealed. Yep. And the appellate court can decide, what to do with that. The court goes on to cite other case law saying the verdict shall be unanimous. It shall be a general verdict returned by a jury to the judge in open court. The jury shall file a verdict slip with the clerk upon the return of a verdict. So the judge is saying without any of those things happening, there is no verdict. It doesn't matter what they discussed in the jury room. If you don't, the judge is saying, if you don't come into open court and render a verdict and fill out the verdict slip, then there is no verdict. The problem is, though, if the jury thinks they can't fill out one verdict slip and not all three, then what do? And that's the problem. The confusion here is the problem. It goes on to say, as such, the weight of final adjudication cannot be given to any juror action that is not returned in a final verdict, and the distinction must be made between agreement on a verdict, a return, receipt, and recording of a verdict. So the court is saying an agreement is not enough. You must have the receipts, screenshot, timeline, fucking everything. This is the court version of receipt, screenshot, timeline. The receipts, screenshot, timeline are, you have to have an agreement, you have to have a return, a receipt, and it has to be recorded in open court. And without all of that, there is no verdict. Well, that's what Emily, keep fucking reading. Because there was no open and public verdict affirmed in open court rendered in this case, the defendant was not acquitted of any of the charges. And that's why the judge is making this ruling. The only unanimous act of the jury here was their representation to the court that they were at an impasse and unable to agree whether the Commonwealth had established beyond a reasonable doubt the elements of the charges. The purported later attestations, she's still going with purported, the purported later attestations by some jurors after they had been dismissed that the jury had in fact agreed on some of the charges during deliberations do not have, quote, the force of a final verdict. And then they quote the cases that the defense has quoted, Commonwealth versus Floyd, and the quote that's a juvenile. It goes on to say after mistrial was declared due to deadlock, judge did not err in refusing to accept signed verdict slips recovered from deliberation room showing not guilty because, quote, it is not enough to show the jury may have agreed on some issues at some time. If that limited showing were to control, uncertainties would be invited. Court hates uncertainty. Look, we all hate uncertainty. Uncertainty is frustrating. We all hate uncertainty, but in this case, the resolution of uncertainty is different. Oh, I chat, I see you. Amarelius, thank you for asking the questions. There were not, let me be clear, there were no signed verdict slips in this case. Chat, come back. There were no signed verdict slips in this case. The court is citing the facts of the juvenile case. And we have gone through it. I think there's confusion every time we read that case. Those are the facts of the other case. And so when you look at the way this is written, as we're breaking down legal writing, the court is going through the facts of that other case. Do we see the way that it's in parentheses? So as we look at the judge's ruling, we go to the period and it says, see a juvenile 392 mass at 57, and then the parentheses. The parentheses are telling you that this is the facts from the juvenile case. So in the world of legal writing, which I know is hard if you're just listening, in the world of legal writing, that is quoting that other case. So it is giving you the parentheses to tell you that that's what happened in that other case. And in that other case, it was after the mistrial was declared due to deadlock. The judge did not err in refusing to accept signed verdict slips recovered from deliberation room showing not guilty. So in that case, that is that case law that the quote is citing. So hopefully that helps everybody. Are we good? Chat, are we good? Are we good? You're not the only, take a breath. I know it can be confusing, especially when you're just listening to it. Hopefully we've done a little bit of a deep dive into legal writing. No worries. I know you're not good overall. I see you, chat, but hopefully we're good on that point. There were no signed verdict slips in this case. We know that the verdict slips were not signed from the last defense reply, that the verdict slips in this case were not filled out at all. Lisa, this is a great question in the chat. I'm going to hold it till we get to Q&A and we'll talk about it. It's a really good question. All right, let's continue on. There were no signed verdict slips in this case. That is an underlying case that both sides have relied on. There's another case, Bluford versus Arkansas. This is from the Bluford case. Double jeopardy did not bar retrial after hung jury where the foreperson reported unanimous vote on an offense before deliberations had concluded, but a deadlock at the conclusion. So the defense was arguing whether or not the verdict was final. And in these other cases that the defense is distinguishing as we're getting into legal thought and legal writing, the defense was distinguishing those cases, arguing that in those cases, some verdicts had been reached, and then the jury had deadlocked on some and then been sent back to the jury room. Because they had been sent back to the jury room to continue deliberations, those previous verdicts reached before they went back to the verdict room are null, essentially. They don't count because deliberations weren't concluded. And those verdict forms never came back out to open court to render a verdict. And this, the lawyers talk about it being horse trading in the jury room, but do jurors compromise? Yes. And so when people are hung on some charges, but not all, you can end up with compromise verdicts or people saying, you know what, I'm not going to vote this way or that way on that count because you're not going to vote this way or that way on that count. So we're not doing any of it. So when jurors go back to deliberate, it can unwind everything. And you can get jurors being like, fine, then we'll have no verdicts, then nothing. So that's why the case law allows for, even if a jury rendered verdicts on some counts and then went back to deliberate, those aren't considered final verdicts. So that's the case law that they are trying to distinguish. They go on to say the defense argues that it is elevating form over substance to not accept the statements in the affidavits. I read that awkwardly. The defendant argues that it is elevating form over substance to not accept that the statements in the affidavits reflect an acquittal of the defendant on, this says defendants, but it's defendant, of the defendant on counts 1 and 3. However, the rendering of a verdict in open court is not I'm going to go with administrative. It means the same thing. It's not an administrative act as the defendant contends. Rather, it communicates the finality of the deliberations, and its pronouncement in open court ensures its unanimity, right? Because then there's opportunity to question it. It goes on to cite the juvenile case, quote, public affirmation in open court provides safeguards against mistakes. Your Honor, the case law says public affirmation in open court provides safeguards against mistakes. So if that's true, and just following the line of thought from the Massachusetts Supreme Court, then wouldn't affirmation that they are deadlocked on all counts also provide safeguards against mistakes? Maybe? Emily, why are you gripping your mic for dear life? Because I am frustrated. Again, you take people out of their lives for 10 weeks. I'm just saying, public affirmation in open court provides safeguards against mistakes. We're all in agreement about that. Pull the jury! Because it really does seem genuinely that the jury was under the impression from the instructions they'd been given that they could not fill in any verdict slip till they had reached verdicts on all counts. So if you ask, then we safeguard against mistakes. But I'll continue. The court's ruling says, indeed, the authority upon which the defendant relies places particular importance upon the jury's pronouncement of its findings in open court. Excuse me, defense, the case you cite says that it's important. And this is from the Bluford. Do I keep saying Buford? I do. I keep saying Buford. Bluford. The Bluford case. This is from Sotomayor's dissension. Dissenting opinions can give information, but they are not, well, they're not the controlling opinion. They're not the majority, but this is from Sotomayor's dissenting opinion, arguing that the forewoman's announcement in open court that the jury was, quote, unanimous against conviction on capital and first-degree murder was an acquittal for double jeopardy purposes, footnote 5. In written and oral argument, the defendant also relies on language from Taylor. Taylor discussed whether a judicial determination to terminate proceeding based on a procedural ground implicated double jeopardy. The Supreme Court explained, quote, what constitutes an acquittal is not to be controlled by the form of the judge's action, and that the determination does not depend on check marks on a form. This language in Taylor does not inform the court as to the circumstances here. Well, okay, then the court's like, yeah, I disagree. And the Taylor case is not what the court is relying on. The court's like, I do not find that instructive. So the court is putting in a footnote saying that the court has distinguished that case and that language that is relied on by the defense. The court goes on to say in this order, thus, quote, verdict in substance is a, quote, final collective decision reached after full deliberation, consideration, and compromise among individual jurors. And when that decision is announced in open court, it becomes entitled to a full double jeopardy protection, citing Commonwealth versus Roth. And then it goes on to say, declining to give effect to the verdict received from the lips of the foreman in open court. Sometimes the courts write things in there are times, man, it's like, until we receive it from the lips of the foreperson in open court, we will not consider it. Don't make me start singing Lips of an Angel. The way I loved that song when it came out, The way I listen to it now going, wait a second. I missed the point. I missed the point. How many of you know exactly what I'm talking about? Look, I missed the point. I missed the point. Let's continue on. I've distracted myself. Let's see. Commonwealth versus Roth, declining to give effect to the verdict received from the lips of the foreman in open court would elevate form over substance. Where there was no verdict announced in open court here, retrial of the defendant does not violate the principle of double jeopardy. So that's the courts coming to the end. The end of the rest of this. Look, the court's saying there is no double jeopardy. We have not heard it from the lips of the jury people. And because of that, there was no verdict in court. And because there's no verdict in court, in open court, it is not a final verdict. Because it's not a final verdict, then there is no double jeopardy. There is no acquittal on any of the charges. Double jeopardy is not at risk here. The end. Now we're going to get into the easier question, the manifest necessity of mistrial. So we're going to get into the easier question. What page are we on? Page 11. I'm wondering if the judge is even going to address at this point, pause, is the judge even going to address the fact that the defense also asked that we just ask the jurors more? Like, are we going to get to that? I don't know, but I want to know. Let's see if we get there. I don't know. Manifest necessity of mistrial. The defendant's motion to dismiss also argues that double jeopardy bars reprosecution because she did not consent to a mistrial and there was no manifest necessity to declare one. This argument, too, is without merit. The court goes on to say, quote, a defendant's consent to a mistrial removes any double jeopardy bar to retrial. And then it cites the case law. Consent must be explicit. Consent may be explicit or implicit. Explicit consent may occur by either moving for a mistrial or agreeing to one. Consent to a mistrial may be implied, quote, where the defendant had the opportunity to object to the declaration of a mistrial and failed to do so. And then they're citing another case law, United States versus McIntosh. From that case, the court cites where the defendant sits silently by and does not object to the declaration of a mistrial, even though he has fair opportunity to do so, a court may presume his consent. So the court's like, nah, you consented to the mistrial. United States versus U, also citing from that case, a court may infer consent only where the circumstances positively indicate a defendant's willingness to acquiesce in the mistrial order. Citing Goldstein, the court says consent to a mistrial need not be expressed but may be implied from the totality of the circumstances attendant to the declaration of a mistrial. Well, let's see how the court evaluates this. As noted, the court here declared a mistrial after the jury reported 3 times that they were deadlocked. After the second time, the court determined that the jury had engaged in due and thorough deliberations and gave the Tui Rodriguez instruction before sending the jury to deliberate further. Massachusetts General Laws 234A, Section 68C provides that if, quote, a jury after due and thorough deliberation returns to court without having agreed on a verdict, the court may state anew the evidence or any part of the evidence, explain to them anew the law applicable to the case, and send them out for further deliberation. But if they return a second time without having agreed on a verdict, they shall not be sent out again without their own consent unless they ask from the court for some further explanation of the law. So this is the law from the laws of the Commonwealth and then the case law. And then citing that case law, the court cites saying, quote, if after due and thorough deliberation, the jury twice advises the judge that they are unable to reach a verdict, the judge may not properly send the jury out again without their consent unless the jury asks for further explanation. And now the judge is going to cite their note. In their note to the court, the jury specifically stated, quote, to continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs, making it clear that they would not consent to continuing their deliberations. So there's law here in Massachusetts that says you can't just keep sending them back ad nauseum. You can't just go like, okay, cute, go deliberate more. So they came back 3 times, not just twice. The court then gets into Yannetti. Attorney Yannetti twice. Attorney Yannetti twice argued for the court to give the Tui Rodriguez instruction, the final step before the court would declare a mistrial. We knew, I said this argument was coming when we knew this. So, counsel's request for Tui Rodriguez instruction, and this is citing Ray versus Commonwealth. Counsel's request for Tui Rodriguez instruction, quote, permitted the inference that both parties were provided an opportunity to be heard on possible alternatives to a mistrial. And they did argue for it twice, specifically on Friday, June 28th, after 3 days of deliberations, when the jury sent their first note indicating that they had engaged in a, quote, exhaustive review of the evidence and had, quote, had been unable to reach a unanimous verdict. Attorney Yannetti argued that the jury had engaged in due and thorough deliberations, was at an impasse, and should be given the Tui Rodriguez instruction. He did. The following Monday, when the jury sent a second note after deliberating approximately 2 hours stating that consensus was unattainable, Yannetti again argued that due and thorough deliberations had occurred and described the jury as hopelessly deadlocked. He did. Defense counsel, in arguing twice that due and thorough deliberations had occurred and pushing for the instruction, presumably was aware of the legal implications if the jury returned deadlock again. Nevertheless, in a remarkable turnaround, sass. Nevertheless, in a remarkable turnaround, defense counsel now the judge is not happy, now argues that the result they twice advocated for was sudden and unexpected. The judge is like, you knew what was coming after the Tui Rodriguez instruction. I don't think she's wrong on that. They knew what was coming. You give the Tui Rodriguez instruction. If they knock 3 times, then you're declaring a mistrial, right? They know that. So the language is strong. The language is very strong. Although the court did not specifically ask defense counsel if they had any objection to the declaration of a mistrial, counsel had multiple opportunities to voice an objection if they in fact had one. She's like, y'all are mad after the fact, but you weren't mad then. We got some Judge Sass going on. I'm just not happy. Counsel had multiple opportunities to voice an objection if they in fact had one. And those multiple opportunities would be when they were advocating to read the Tui Rodriguez instruction. While waiting for the jury to enter the courtroom, after the court announced the jury was at an impasse on the afternoon of July 1st, defense counsel could have asked to be heard on the issue. I mean, there were moments. During the subsequent decision about scheduling a status hearing right after the court declared a mistrial, counsel had yet another opportunity to inform the court of its dissatisfaction, and they didn't. It goes on to say, lastly, counsel could have communicated to the court any objection or request to poll the jurors. There's that. Or request to poll the jurors while the jury was still at the courthouse waiting in the deliberation room after the declaration of a mistrial. So the judge is like, y'all didn't ask. Y'all didn't ask. Y'all didn't ask to poll the jury. The jurors could have been polled. None of you asked. They didn't ask. They didn't ask during scheduling. They didn't sit there and go, excuse me, Your Honor, before the jurors leave, could we just ask them if they're hung as to all counts? And would the court have brought them back in? I don't know. Would it have preserved the issue better? Maybe. This is why lawyering is hard. You have to make these decisions immediately in the moment. And they did not ask. And the court is like, and you did not ask. And that, again, is why it is difficult. You have to. And it's interesting to me that she's saying or indicating that if they had asked while they were in that scheduling portion, that something might have been different. So They could have asked a poll. Nobody asked. So the judge wasn't going to poll unless somebody asked. So, all right. Lastly, counsel could have communicated to the court any objection or request to poll the jurors while the jury was still at the courthouse waiting in the deliberation room after the declaration of a mistrial. Instead, defense counsel said nothing to the court about the mistrial and then proceeded to the courthouse steps where Attorney Jackson declared to the media and onlookers that the Commonwealth failed miserably and will continue to fail with its prosecution of the defendant. Fucking hell. Okay, that's a lot of sass. Your Honor, she's like, they had a lot to say to the media. Woo, boy. Footnote 6 is a link to YouTube. Okay, the judge is like, don't come at me for doing something wrong. Y'all didn't ask. Y'all didn't ask, and you had enough presence of mind to go out and talk to the media, so miss me. Okay, Your Honor. Oh, we're not done yet. Emily, you should have kept reading. The judge goes on to say it strains credulity to believe that if defense counsel wanted to voice any objection to the court, it would not have been heard. Significantly, defense counsel were no shrinking violets. No, no, they weren't. Oh. These attorneys made themselves heard. Even when I didn't want to hear them, they made themselves heard is what it's giving. Wow. Wow. Significantly, defense counsel were no shrinking violets. Neither Attorney Jackson nor Attorney Yannetti has ever needed this court to inquire whether counsel had an objection in order to be heard, and the court has never denied counsel the opportunity to be heard in open court or at sidebar. The court reconvened many times at counsel's request. Just days before the declaration of a mistrial, defense counsel asked to address the court while the jury was deliberating to raise an objection about the verdict slip. Attorney Jackson was not shy in informing the court that he wanted to, quote, make his argument that the court's decision about the verdict slip was, quote, not how it should be, and it's over our strong objection, footnote 7. A link to YouTube. Attorney Jackson went so far as to suggest that it was almost like the court is directing a verdict of the subordinate charges by not making the changes he wanted. The court's just going to continue to butt heads with this defense team. The court finds it hard to believe that when counsel heard that the jury was at an impasse for the third time and a mistrial was inevitable, at perhaps the most crucial point in the trial, counsel would sit silently if they did not consent to a mistrial. As such, the court does not credit Attorney Jackson's averment that he lacked an opportunity to be heard. The court's like, no, not a chance. You had an opportunity to be heard. You spoke up and made yourself known at every other opportunity. And after this, y'all sat silent. This one's not on me. That's what the court's saying. As such, the court does not credit Attorney Jackson's averment that he lacked an opportunity to be heard. Defense counsel's silence, despite ample opportunity to be heard, is deemed consent. The court goes on to cite a variety of cases, saying on the first one, when the trial judge on own initiative declared a mistrial, defendant's silence was deemed consent when there was ample time to object despite not being directly asked by the judge. Another case saying silence was not consent where the judge's conduct was so intimidating to defense counsel as to foreclose any objection from defense counsel to the declaration of the mistrial, which isn't the case here. The court goes on to say, even assuming arguendo that the defendant did not consent to the mistrial, the law is clear that a retrial is permissible so long as there was manifest necessity for a mistrial. And I agree that there was manifest necessity here. I think an appellate court would agree as well. It goes on to cite the Taylor case, saying the trial judge's belief that the trial judge's belief that the jury is unable to reach a verdict has long been considered the classic basis for a proper mistrial. This jury was pretty clear about their mistrial, so I think that any appellate court would say, even if the defense didn't consent, there was manifest necessity. Even if the defense here had said, we do not consent to a mistrial, arguendo, hey, we don't consent to a mistrial, this judge still would have found a mistrial. And if that was appealed, the appellate court still would say on all of the case law that there was manifest necessity for a mistrial, and that the judge sending the jury back without their consent is actually contrary to both statutory and case law. On this, the court is correct. Yeah, this is not the defense's best argument. The court is not wrong here. It goes on to say, because the court had no doubt based on the jury notes to the court that it was unable to reach a unanimous verdict, and the jury represented to the court that continued deliberations would be futile, there was a manifest necessity for mistrial based on the deadlock. I agree with that. As stated above, the foreperson on behalf of the jury in this case sent the court 3 notes, none of which indicated agreement on any of the charges. I think that's really the heart of where the court is not going to ask, to hear from the jurors. I wonder if the court's going to address it. We're how many pages in now? We are pages and pages in. I just wonder if we're going to have the court even address it at all. So we'll see. It says, as stated above, the foreperson on behalf of the jury in this case sent the court 3 notes, none of which indicated agreement on any of the charges. And that I agree. The jury did not say at one point, hey, we don't know what to do. We've reached verdicts on some of the counts. And that is a problem here. If it's frustrating because, again, how do you know what you don't know to ask? But the jury never indicated we're unclear, we're hung on some, we're hung on this, we're hung on that. All right. So in the first note, so the judge is going to relitigate this. In the first note, the jury wrote that they had been unable to reach a unanimous verdict. In the second note, they stated that they were deeply divided by fundamental differences in our opinions and state of mind, and that consensus is unattainable. In their third and final note, after they had been given the Tui Rodriguez instruction, the jury stated that they continued to be at an impasse. They described themselves as starkly divided on their perspectives on the evidence, explaining. We're going to hear it again. Run that back. It's like one more time. Muzzerlina V said in Super Chat, so arguendo is a real word. I thought it was just Emily slang. No, arguendo, real word used in the law. It's it's the shortened legal version of arguing that, or to argue on the other side, or to play devil's advocate. It is something that comes up in my household a lot, just because my son will say things like, the reason I should have a motorcycle is, and I will say, taking that as true, arguendo. But arguendo, hear me out on the other side. I'm going to go with you, but hear me out on the other side that you don't have a driver's license yet. So a motorcycle is not what we're doing. And also there are reasons that you are not getting a motorcycle. And the first part of that is going to be, if you are not paying your vehicle insurance, you are not driving a motorcycle. Once you pay for insurance, we can talk about a dirt bike and we'll go from there. Also, we'll continue on with my, I don't trust other people on the road with my son. But arguendo being that in argument on the other side, or to play devil's advocate. It is the court version of to play devil's advocate. So let us continue. The court's going to rehash this again. The jury said that I think I zoomed too far. The jury said that their consensus is unattainable. In their third and final note, that after they had been given Tui Rodriguez, they were at an impasse. They were starkly divided. Their perspectives of the evidence, explaining, quote, some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. The only reasonable interpretation of these notes, and this is not the court saying arguendo. This is the court saying there is no other interpretation of this shit. This is the only way it can be interpreted. And the judge is writing this knowing that it's going to be appealed, right? So the court is writing this for the appellate court at this point, saying there's only one interpretation of this. There's only one way that things come down on this. The court is saying the only reasonable interpretation of these notes, and specifically the final note, was that the jury could not agree on any of the 3 charges and further deliberations would serve no purpose, footnote 8. Given the care that went into writing the notes and how articulate they express the jurors' disagreement, it strikes this court as odd that there was no inkling of an indication of agreement in the content of the notes, or that if the jurors were uncertain whether they could return a partial verdict, they would not have asked the court. And I get that perspective. The judge is sitting there going, these jurors have very strongly expressed that they are at an impasse and have very thoroughly articulated that they do not want to compromise their deeply held beliefs. So the court is saying it's hard for me to believe that if they truly were unaware that they could return a partial verdict, that they would not have asked. And the appellate court might agree with the court on that. The notes give no inkling of it. It says the only reasonable interpretation of these notes, and specifically the final note, was that the jury could not agree on any of the 3 charges. For the defense to now claim that the notes were susceptible to different interpretations such that the court should have inquired further rings hollow. The court's like, nope. Particularly where Attorney Yannetti had twice argued that the jury had engaged in due and thorough deliberations and could not agree. So the court is saying, Yannetti, you showed up in court and you said, no, Your Honor, this jury has been thorough. They have given due consideration. They have been as clear as a bell. Give them the Tui Rodriguez instruction. The judge is saying, you can't come back round and then say it wasn't clear. Well, Your Honor, they're defense attorneys. That's their job. So that's their job. The court goes on to cite another case saying that there was no abuse of discretion in declaring a mistrial given the increasingly adamant manner in which the jurors announced that they were deadlocked. Were the juries adamant? Moreover, defense counsel's conduct immediately after the declaration of a mistrial in no way suggests that they thought otherwise. What do you think? The defendant contends that the court failed to carefully consider that as an alternative to a mistrial, it could have simply asked the jury to specify the charges on which it was deadlocked. Defendant Karen Reed's motion to dismiss at paragraph 8. However, quote, the question whether a mistrial is appropriate in the circumstances of a given case is not answered by the application of a mechanical formula. Rather, the court considers several factors as the statements in a jury's note concerning their inability to reach an agreement, the time spent in deliberations, and the length and complexity of the trial. I mean, I think the court is just continuing to relitigate this. The court goes on to cite other case laws saying, we have never required a trial judge before declaring a mistrial based on a jury deadlock to force the jury to deliberate for a minimum period of time, to question the jurors individually, to consult with or obtain the consent of the prosecutor or defense counsel, to issue a supplementary jury instruction, or to consider any other means of breaking an impasse. It's at the discretion of the court. Where here the jury had been deliberating for 5 days, had returned to court 3 times, stating they could not agree, had been given the Tui Rodriguez instruction, and returned hours later with a note plainly indicating that they could not agree as to the elements of the charges, and that to continue to deliberate would be futile, asking the jury on which charges they were deadlocked was not necessary to determine that there was a manifest necessity for a mistrial. And then it's citing case law to support that position. The court goes on to say, moreover, the defendant's argument ignores the fact that one of 3 charges had lesser included offenses. I thought your argument was ignoring that a little bit. Gonna be honest. Moreover, the defendant's argument ignores the fact that one of the 3 charges had lesser included offenses. I think that they brought that up a lot as a point of confusion, and that you're not. What? Okay. The court goes on to say, therefore, if upon questioning the jury had indicated to the court that they were not deadlocked on all charges, the only option would have been for the court to send the jury back to further deliberations. I think that's not accurate, or at least I disagree fervently. I don't think that was the only option. The court is seeing this the way that the Commonwealth sees that, but I don't think that's the only option. I think the option could have been to say, and again, I don't practice in Massachusetts, but how that would have played out in the courts that I have practiced in would have been, go back and continue your deliberations. If you have reached verdicts on some of the charges, fill out those verdict slips. That's how that would have gone. Fill out the verdict slips on the counts you have reached verdicts on, and then return to court. The court said, if upon questioning the jury had indicated to the court that they were not deadlocked on all charges, the only option would have been for the court to send the jury back for further deliberations. I disagree. I can't imagine that that is the law in Massachusetts. In the juvenile case, it says the judge should not inquire as to partial verdicts on lesser included offenses. I don't agree. Rage. I don't agree. This is what the Commonwealth was arguing too. And I disagree with the Commonwealth, and I disagree with the court here. The judge is the judge. Am I an expert in the law in the state of Massachusetts? No. But I don't think that inquiring if you have reached some verdicts, fill out the verdict slip on those verdicts, is inquiring into partial verdicts on lesser included offenses. Come on. I don't think that's an accurate interpretation of it. I don't think there's much that can be done about it now, but I disagree with that interpretation. It says such action would be improperly coercive under the circumstances. Again, this is mirroring the Commonwealth's side on this, and I disagree with the Commonwealth's argument, and I disagree that that's what the judge said. Or no, I don't disagree that's what the judge said. I disagree with how the judge is getting there. This is what the judge is saying. I just don't agree. This doesn't make logical sense in my brain, because it can't be the case that no one in the fucking state of Massachusetts has ever returned a split verdict. That is not even possible. Okay. This is not the position this case stands for. I disagree, because again, telling them to go back and fill out the verdict slips on the verdicts that they've reached is not inquiring as to partial verdicts on lesser included offenses. This is splitting the same hairs as the Commonwealth, and I disagree with it. Maybe the appellate court will tell her, but I disagree with this interpretation. Am I a judge in the state of Massachusetts? No. But I can't imagine that this is what the court has intended, and maybe the appellate court will tell us so. Here's the thing I want to be clear on. This is not the issue. This misinterpretation, or I think it's a misinterpretation, this interpretation doesn't change anything. Even if the appellate court came back and said, actually, no, that wasn't the only option, this is not going to change anything. This is not instructive on anything. The court is splitting hairs and agreeing with the Commonwealth on this, but it truly, if the appellate court came back and said, you know what, no, you're allowed to have a partial verdict, the only option was not to send them back to deliberate. You could have told them to fill out the verdict forms on the verdict that they had reached. It changes nothing, honestly. So though it's frustrating, and I think I have expressed that frustration to you, changing the court's interpretation or view of this changes nothing. It doesn't change what an appellate court would do here. It goes, the judge says that inquiring as to whether they had reached partial verdicts is improperly coercive under the circumstances. Disagree. It has been repeatedly recognized that deadlocked juries are particularly susceptible to coercion. And then the court is citing the Roth case, quote, where the jurors have twice reported themselves deadlocked and they have already heard the Tui Rodriguez charge, a judge's inquiry concerning partial verdicts cannot avoid communicating to the jury the judge's desire to salvage something from the trial. And I can understand, given that case law, where the court is hesitant to pull the jury. However, when asked from counsel, they're allowed to, and that's why the judge is pushing this back on. Counsel didn't ask. Because under this law, the court's like, look, we could cause a further issue by asking. And the court is saying under this law, and I agree more with the court's reading of Roth than I do with a juvenile case. And the Roth case is saying a judge's inquiry concerning partial verdicts cannot avoid communicating to the jury the judge's desire to salvage something. And that case law, I think, is a much stronger point than the others. Where here the jury had before it one indictment, which included lesser included offenses, had 3 separate times reported themselves deadlocked on separate charges, had already heard the Tui Rodriguez charge, and had sent a final note indicating that continued deliberations would only serve to force them to compromise their deeply held beliefs. Sending them to deliberate further would have been improperly coercive, footnote 9. And this is within the judge's discretion. And I don't think an appellate court will find this to be an abuse of discretion. This is within the court's discretion, and I think the appellate court's not going to mess with this part at all. Footnote 9, it is the court's, apologies. It is the court's view under these circumstances, even posing the question to the jury of whether they actually were deadlocked would have implied to the jurors that the court wanted them to resume deliberations and reach a verdict. Given that Attorney Jackson had already she's throwing this back on the defense. Given that Attorney Jackson had already expressed concern that the court was directing a verdict of the subordinate charges, the court was extremely cautious to not give any appearance of partiality. Okay. So the court is saying, look, the court is giving us her perspective. Agree, disagree. The court is giving us her perspective. The court's perspective is Attorney Jackson already said that I was pushing it. And so I didn't want to push it further. And so I am relying on the case law from Roth, the Massachusetts Supreme Court, that says any questioning of the jury would be improperly coercive, and the jurors' notes were incredibly clear. And between those two things, plus the defense not asking to poll the jury, I'm not saying shit because the case law supports me not saying shit. So that's where the court is standing on, I'm not asking. And if the court had asked and they had come back with guilty verdicts, if the court had asked and they had come back with guilty verdicts, those would have been appealed. And the appellate argument would have been that the judge inquiring as of the jury was improperly coercive. And the judge is aware that that would have been the argument if they had come back the other way. Cat Love in the chat said, I remember the defense celebrating this as a victory. They did. They did. Yes, they did. The court goes on to say, the defendant's argument suggests that questioning or polling jurors who report a deadlock is best practice, or at least commonly done by trial judges. I don't disagree. However, the defendant has not cited any cases saying as much, and indeed, such an inquiry is not undertaken in the regular course, footnote 10. The defendant relies on Commonwealth versus Foster and Commonwealth versus LaFontaine to argue that there would be nothing coercive about asking a jury reporting a deadlock whether they had reached a unanimous verdict on any of the counts, because neither the jury in Foster nor the jury in LaFontaine reported being deadlocked in its deliberations, and none of the offensive charged had lesser included offenses. There was clearly no risk of coercion in the courts seeking partial verdicts on the separate indictments in that case. The circumstances here are markedly different. And again, the court is holding on to the fact that count 2 has lesser included and that the case law talks about count 2 having lesser included. But I think what's going to be instructive to the appellate court here is that the defense did not ask to poll the jury. And the appellate court's going to look at that and say, the defense didn't ask to poll the jury. So the judge was exercising caution, because if the jury had been polled and stuff had come back guilty, it would have immediately been appealed saying that the judge was coercive. And whether you like this judge or don't like this judge, you know that that's exactly what would have happened, because that's a defense attorney's job. They go on to say that for a judge to make such an inquiry on her own accord could impede upon the strategic decision of counsel not to make such a request. The defendant's argument is based on hindsight. No one other than the jury knew that questioning the jurors as to their deadlock would have yielded a favorable outcome for the defendant. It is likely for that reason defense counsel consented to this court's declaration of a mistrial. Post-trial inquiry. Finally, it's being addressed. This is what I wanted to know. This is what I wanted to know. Were we ever going to get here? Yes, we did. On what page? What page are we even on? I don't even know. What? 19. 19 of 21, and we finally get there. Post-trial inquiry. The defendant alternatively suggests that the court allow counsel to conduct a post-trial inquiry of the jurors to substantiate the evidence of an acquittal. Defendant Karen Reed's motion to dismiss. The court, one sentence. Such an inquiry is impermissible. The defendant's argument relies solely on Commonwealth versus McCallop. In McCallop, the Supreme Judicial Court held that the trial court should have allowed the defendant's motion for jurors' names and contact information based on the post-trial statement of a deliberating juror regarding racist statements made during deliberation. The Supreme Judicial Court explained, quote, the presence of even one juror who was not impartial violated the defendant's right to a trial by an impartial jury. And then Commonwealth versus McCowan goes on to say, recognizing that, quote, racial bias in the jury system is a familiar and reoccurring evil that, if left unaddressed, would risk systematic injury to the administration of justice, the McCallop court held that the defendant should have been given a fair opportunity to obtain an affidavit from that juror setting forth with some specificity who among the jurors made statements reflecting racial bias and the statements that were made. This is one of the very narrow permissible areas of inquiry where there has been bias in the deliberation room that the court is allowed to inquire about the deliberation, because then you don't have an impartial jury. That area and external influence are really all you're allowed to ask for. So this is why this case was brought up, and this is why the court is addressing this case. The court goes on to cite several other cases saying that the defendant's argument here does not implicate racial bias or her right to receive an impartial trial. I don't disagree with the court on that. Thus, the reasoning the court employed in McCallop does not extend to this case. And the defense acknowledged that in their motion, saying there are ways for this to happen. It just hasn't happened in this circumstance. And then the court cited Commonwealth versus D. Benedetto, declining to extend racial bias exception to inquiry of jury unanimity because infection of the criminal justice system with racial or ethnic bias is a unique type of constitutional deprivation that requires a vigilant response not warranted in the circumstances presented here. And that's what the court's going to rely on here. The defendant's request effectively seeks permission from the court to inquire from deliberating jurors that which is impermissible. Information regarding the substance of the jury's deliberations. I just don't agree. I just don't agree. I agree that you can't. I agree that you cannot inquire as to the substance of jury deliberations. I don't agree that that's the request here. I just don't agree. I just don't agree. I'm not the judge, and there's nothing I can do, but I am not the judge. Maybe the appellate court will say, hey, we think the jury can be. We think a jury inquiry can happen here. I don't think they'll do that, and I'll tell you why when we get to the end of this. I can see the appellate court shutting this down, but I disagree with the court's reasoning here. The defendant's request effectively seeks permission from the court to inquire from deliberating jurors that which is impermissible, information regarding the substance of the jury's deliberations. The secrecy of jury deliberations has served as a bedrock of our judicial system. An inquiry into the jury's deliberative process would intrude improperly into the jury's function, citing Commonwealth versus Moore. The court says it is simply not the case, given the content of the jury's final note to the court, that any inquiry of the jurors now could be limited solely to the results of the deliberative process and not implicate the process itself. I'm going to keep reading. I want to tell me why. Any inquiry would necessarily require the court to understand why the jury's final note communicated a deadlock on charges when post-trial certain deliberating jurors were purportedly stating that the jury was in fact unanimous on most of the charges. While the defendant contends that the conflict is reflective of the fact that the instructions given to the jury by the court were confusing, determining whether this is true would necessarily require inquiry into the back and forth among jurors during deliberation. That part I agreed with. That part I agree with. I don't agree with the other part. And then they're citing the Di Benedetto. I'm putting too many consonants in there. Apologies. The judge is precluded from inquiring into the internal decision-making process of the jury as a whole or of the individual juror being questioned. Accordingly, evidence that jurors misunderstood the instructions of the presiding judge cannot be considered. Well, that's a little bit on the nose, isn't it? So you've got case law from the Massachusetts Appellate Court saying evidence that jurors misunderstood the instructions cannot be considered. Thus, such an inquiry is prohibited. And I don't think the appellate court's going to rethink that at all. That's coming from their court. The defense counsel has not cited one case suggesting the post-trial inquiry they now seek is appropriate or that it could change the outcome of the proceedings. Footnote 11. Cases the defense counsel referred to at hearing on this motion concerning post-trial inquiry of jurors were juror bias or outside influence was at issue are readily distinguishable from the circumstances here, and that's also true. The outside influence cases, these are the two areas where courts agree that you can inquire. Bias and outside influence. This is not that. We don't have bias and we don't have outside influence. What we have is a jury that says they reached a verdict even though they didn't say in their notes that they reached a verdict. And that's incredibly frustrating. The court goes on to say, for the reasons already discussed, an acquittal of the defendant now on indictments 1 and 3, based on conclusions purportedly reached during the jury's deliberations, is not permissible. Therefore, there is no reason for the court to allow post-trial inquiry of the jurors. And then citing the juvenile case, again, no error in denial of motion to subpoena the foreman where process would only serve to impeach jury's report to the judge in open court. Conclusion and order. This court recognizes that the bar on retrials following acquittals is perhaps the most fundamental rule in history of double jeopardy jurisprudence. However, where there was no acquittal on any of the charges in the defendant's first trial, there is no risk of subjecting the defendant to double jeopardy by retrial on all of the charges. Therefore, the defendant's motion to dismiss is denied. And that is the end of the court's inquiry. The court will not allow the jurors to be asked, and the court is not granting a motion to dismiss. I don't think the court can grant a motion to dismiss. Let's summarize that and then go to questions, shall we? I didn't hear that at all. Hold on. Maybe you didn't either. Let's try it again. There we go. At the end of 21 pages, the court had some moments of snark, but made very clear that the judge was not granting any dismissals and was not allowing for the jurors to be inquired of. The court set forth that there are two circumstances accepted under case law where a jury can be inquired of, and that is issues of bias inside the jury deliberation room and issues of outside interference like we saw in the Murdaugh case. The court says very clearly there is no argument from any of the parties that those two situations are at play. Therefore, there will be no inquiry into the jury, because inquiring into the jury would necessitate asking the jury why their final note said they were unable to reach a verdict on the charges, and yet they are saying they now have verdicts on two of the charges after deliberations ended, after the mistrial was declared. And the court said that that would be getting into the jury's deliberative process, not simply inquiring as to the result. So the court is not allowing further inquiry of the jurors. The court is not granting a dismissal. I imagine what will happen from here is the defense will say we are disappointed in today's ruling and we will be appealing this decision. And the prosecution will say that this ruling is in line with the long history of case law in Massachusetts, and we will be moving forward with the prosecution of Karen Read on all three counts come January 2025. I imagine that that's what both sides will do when they make statements to the media, because the court in many ways adopted the arguments made by the Commonwealth throughout this ruling, and the court made very clear throughout this ruling that they believe the defense had adequate time to object and the defense had adequate time to ask for the jury to be polled, and the defense did not ask for the jury to be polled. The court also said that the court was not going to poll the jury because it might have gone against the strategy of the defense to not poll the jury, and it might have been seen as impermissibly coercive because there was one count that had lesser included counts. And under case law in Massachusetts, the court believes that inquiring as to a split verdict on counts where there are lesser includeds, the cases have found that that inquiry alone is impermissibly coercive by the court. And the court put in a shady footnote saying, and Attorney Jackson had already said that they believed that the court was trying to coerce, and that was not the exact word used, but already trying to imply a verdict with the way the verdict form was written. And the court said because of the objections of Attorney Jackson during the trial, the court was overly cautious not to overstep and not to make any statement about how she thought this should go, or to make any indication to the jury that there should be a partial verdict by asking for it, given the notes. And given the notes, the jury notes were very clear. And I think that's what's so difficult in this case. And I think that's why the appellate court isn't going to do much with this, because the jury notes said that they had given consideration, that they were deadlocked on charges, that there was nothing that they could do. I don't think that the Court of Appeals will do much with this because they don't want to open up inquiries to juries after the fact. It means that no case would ever be final, and courts like finality. The courts have carved out exceptions for outside influence and bias, and they're not going to carve out a after the fact, go home, think about it more, and be like, we reached a verdict. This is a high profile case, and the courts are not going to want to open a can of worms with whether or not jurors change their mind after going home. The only way to really know if that happened is to inquire of all the jurors, but the court's not going to allow an inquiry of all the jurors. So on this, I think the court and I agree, or I agree with the court with regard to the manifest necessity for a mistrial. I agree with the court on that. I think there was room for the court to allow an inquiry for the jury, the court was not so inclined. Clearly. I disagree with that. I think there was room here. I am not the judge. It is not for me to decide. Do I see what law the court is relying on? Yes. Does that law support the judge's finding here? Yes, it does. The law supports the judge's finding here. Do I wish the judge had allowed the inquiry into the jurors? Yes. Do I understand why the judge didn't? Also, yes. Does that mean I agree with it? No. Is it the unusual case that a jury will have reached a verdict and not communicated it in any way? Yes. This is a very unusual result. You will normally see it manifested in some way in the jury notes. What do we do if we reach a verdict on some but not all of the counts? What do we do then? There was no note ever asking that. And with that, the judge, under the case law that we have seen in this order, the judge can't inquire much more than that. And that's on the case law. Could the appellate court look at it and say, you know what, we disagree with the case law. We think polling the jury is maybe the better way to go. Maybe they could. Maybe they could. But that's not what happened here. And the judge took every opportunity to say, hey, the defense could have asked and they didn't. The defense could have objected more and they didn't. And it is not my role. This is what the judge is saying in this order. It is not my role to overstep the defense attorney's strategy. And that's on them. And then she took a minute to take a dig and say, and they went out and said that this was a win on the steps of the courthouse in front of the media. And here's a link to the YouTube video. Do I think this will change on appeal? Probably not. Do I think the court could have dismissed this? No. The best the defense could have hoped for here is allowing an inquiry of the jurors. Does that stop the jury from coming forward further? No, it doesn't. It doesn't at all. Does it feel like the just result when the jurors are saying, we had a verdict? No, but we don't know if all of the jurors agree with that because we have not heard from all of them and we're not going to hear from all of them, it seems. Could the jurors say to the Commonwealth, dismiss these cases? I mean, they could. The Commonwealth can choose to dismiss the charges. They seem disinclined to acquiesce to that request, but they could choose to do so. I don't think they will. I don't think it's good for the Commonwealth to hear that these jurors did not agree with counts 1 and 3 and then to decide to go ahead and retry it. Do I think this will change an appeal? I think that's I think that would be the unusual result. But yes, the defense can appeal this, and that's where it goes. Will they have time to finish that appeal before this goes to retrial? I mean, we're in August. This is set for retrial in January. Depends on how swiftly the appellate court takes up the issue, or if the appellate court just says, we don't need briefing on this, it's denied. We're not letting you inquire into the jurors. Courts like certainty. And that's in allowing for the jury process to be opened up after people go home, after all the admonitions of staying off the media and everything like that is gone, allows for there to be fuckery after the fact. I'm not saying that that's what I think is happening here. I'm saying that that is the court's biggest concern, is that there can be fuckery with the jury after the fact. And it's why they are very hesitant to open up inquiry into the jury. But I don't think there's any case law that allows the court to dismiss it the way the defense was asking for. That's just the way the law is at the moment. So let's go ahead and answer your questions and hear your frustrations, because I see the frustration in the chat and I get it. So I get it, you know? Let's go ahead and get to questions. Lyndon, good to see you in the chat. Lyndon said, I see the appellate court clarifying the procedure but affirming the denial. And they might. And the thing is, they might take it as an opportunity to make clear, look, when you have counts with lesser includeds and counts without lesser includeds, it's not always improper to inquire if they are split as to all of the indictments versus the charges. Maybe it is for the Judicial Council to clarify some of the language. Maybe it is time to reevaluate those jury instructions and how they are confusing. Case law gets made slowly, law gets changed slowly, and maybe the Judicial Council of Massachusetts looked at this result and goes, yeah, we don't like this result. That is how law changes. When you look at the law and you look at the result and you go, we don't want this to be the outcome. So what needs to change? This is a circumstance where I can see a Judicial Council getting together at their meeting going, this is not the right result. And I can see where the jurors are confused. Let's clarify the language here so it doesn't happen again. So things might change, but this case is a mess. Every single part of this case is a mess. This wouldn't every single part of this case is a mess. The evidence was messy. The state's experts were messy. The testimony was messy. Some of the jury instructions were messy. I think this jury did the best that they could. And I think they tried to follow the instructions that they were given. And I think they did that diligently. Everything else, I think, is a mess. And it's absolutely unfortunate if they reached verdicts that they were not allowed to express that verdict in the way that they felt they needed to. And it's unfortunate that they did not ask, what do we do? It's just very frustrating. So if this retries, will we see a less messy case? I don't know. Probably not. But will we see a change in the jury instructions? Maybe we will. That's how things get changed. Cleopatra said, is it okay or can Karen Read make statements to the media? Is it wise? It's definitely not wise because Karen Read is still facing another trial. So no, I would let the lawyers do that. Let's get to questions. Law nerds, I know it's frustrating when the legal result and what feels like the right result don't align. It feels incredibly frustrating. But the law as it is doesn't allow for there to be much other than the jury's being inquired of. And even if they inquired of the jury, arguendo, give me an arguendo. Give it to me, baby. Wait, no, damn it, that's not the chimes. Give me an arguendo. Arguendo. If the judge intellectually play this out with me, play law school with me, y'all. Just play law school pretend with me. Let's have a law school moment. Arguendo. The judge allows the inquiry of all 12 jurors. And assuming this is our whole hypothetical situation here. The judge allows the inquiry of all 12 jurors. Okay? All 12 jurors come in. They do it in a procedure where the jury identities are kept secret from the public. They do it behind closed doors. All 12 jurors are like, yeah, we came to a verdict. I came to verdicts of not guilty on counts 1 and 3, and we were not unanimous on count 2. Every single juror comes in and agrees. Then what? There is still no process for the court to dismiss the counts. There is still no process for the court to record a verdict. So even if the court allowed an inquiry, even if the 12 jurors came in and said, yeah, we had verdicts, there is still no case law that allows it to then be dismissed. It allows for a stronger argument at the Court of Appeal, yes. But what it really allows for, and what I think the defense really wanted, was it allows for a fuck ton of public pressure on the prosecution. And I think that that's what the court doesn't want. And I think that's what the defense does want. Because if you hear from all 12 jurors, there is nothing other than, okay, then tell the prosecution to dismiss it. Tell the prosecution to dismiss it because they're the only ones at this point that can. It's still not a violation of double jeopardy because the verdict still wasn't recorded. It just puts the defense in a stronger position to argue. But there isn't any law that I have seen that allows there to be a dismissal even if there's an inquiry from the jury. This is very, very different than Murdaugh. in the Murdaugh case, there is room for the verdict to be overturned in a new trial to be granted because of outside influence. Here, there is no case law. There is no law that allows for the dismissal. If there had been a verdict, we wouldn't be here. But there's no fix. So I think it gives the court, this isn't helpful for Karen Reed, but it gives the court room to evaluate the jury instructions and to evaluate whether in this circumstance you can inquire from a jury, and it allows them to hear that. The defense wanted to be able to inquire really to assert public pressure on the prosecution. Because can you imagine being a voter and looking at the DA and being like, really? You've heard from 12 jurors who said that they acquitted and you're still going forward with this. That's what you're choosing to do? Okay. I'm putting the date in my calendar of when your re-election campaign is up. And if you think people don't get feisty over DA elections, when DAs are unpopular, people get feisty about DA elections. So even if you get to an inquiry, it doesn't necessarily change the result. So what do I think the defense will do? Appeal. We knew that that's what they were going to do. They said that they were going to do it before all of this. So frustrating, I know. Wizard said, will there be a new trial? Will the new trial be public like this one? It should be. I don't see why it wouldn't be. It should be. There's no reason to close a trial. The trial will be public in some way. And even if there's a lot of public interest, it will still be public. It will still be public in probably in stream. Brianna King said, is there any way to get a new judge? Not really. I mean, even if they move to change a venue, which they might do, even if they move for a change of venue, there's not really a way to get a new judge because the judge will just go with the case. So let's get to some more of your questions. I see that some of you have mentioned that the defense has made a statement. Let me noodly Google real quick and see if I see that. Let's see if that is readily apparent to me, because I'm not going to keep you here while I am noodly Googling. And let's see. There are quite a lot of articles, of course, about it. But let's see if we see any of the any that say there is a statement from the defense. Let's look at the most recent ones. Let's see. I always look at local media first, so that's where I'm going first. Let's see. I don't see any of these with statements from the defense. Let's see. Reed's attorney, David Yannetti, declined to immediately comment on the ruling when contacted by investigative reporter Ted Daniel, a spokesperson for the Norfolk DA's office, said, we believe the judge's decision is consistent with almost 200 years of case law. Of course they did. We are moving forward to trying the case on January 27th. Well, of course, that's what the DA's office said. So I'll take a look. And if the mods see another one, I know they will let me know. Matthew said, I hope the next trial isn't as long in weeks as the previous one. I think that the defense will be making more motions to curtail the evidence because we didn't need to know where everybody was sitting at the Canton girls varsity basketball game. And we didn't need everyone to tell us it was a high top table. There were so many irrelevant and extraneous details that there was a lot that didn't need to be known. There was a lot that didn't need to be asked. CernatX3 said, can't stay for the live, but wanted to say thank you, Emily and Cruz. Started my paralegal associate's degree classes this week at almost 30 years old. That's amazing. And I wouldn't have had the courage to without the law nerds and Emily's content. Congratulations on embarking on a new adventure. It will be amazing. There are so many paralegals needed. There is an absolute crisis in the courts with a lack of court reporters. There is a tremendous lack of support in the legal profession. There are lots of ways to engage in the profession that are not law school and a lot of ways that don't cost as much as law school. Andrew said, hello from Niagara Falls, Canada. Hello to you in Niagara Falls, Canada. Susan said, do you think the reason they didn't fill out the form was them being confused with the instructions? Susan, based on everything we've seen, I think that is a very high probability, but the judge can't ask that question. So that is tough. So the judge can't ask. Nikki said, aloha, aloha, Nikki. Good to see you. To all the members, it's good to see all the member chats. Thank you so much. Let's hope this case is dismissed for Karen. AI designs, I think we are a very long way from there. Kim asked if I was feeling better. We're getting there. Still tired, but we're getting there. I hope you feel better. Thank you for all the well wishes. Again, being sick is no bueno, but it just happens. It just happens every fall. Truly. Rolling Along said, a commentator said they can do affidavits so their identity won't be known to the public. The jurors could submit affidavits to the attorneys at this point, but there's nothing the judge can do with them. And if they submitted those to the state has to disclose them to the defense, and the state would have to or the Commonwealth would have to confirm their veracity and their accuracy, which would mean they would need to be disclosed. So that's tough. Aaron Evans said, we need fucking demure merch, please. I'll think about it. We will consider it. Becca said, what in the world do you even mean, EDB? I'm very fucking demure. Exactly. Very fucking demure. Very mindful. Always Love said, Emily, we love seeing you feeling so much better. Thank you. Being on some medication has helped. And the tired is real, but the congestion is not as real. Vicky said, love fucking demure. Thank you. Me too. The D in EDB stands for demure. This week we'll go with it. Mama Wolf said, did the defense counsel consent by not objecting? That's what the court said. Even though if the defense had objected, under the law as it is, based on the court's order, even if the defense had objected to the mistrial, there was still manifest necessity for a mistrial. Leonard Soph said, but they didn't consent. They didn't get a chance. And Leonard Soph, I hear you. Even if the court said, arguendo, even if the court said, hey, we don't consent to a mistrial, the court would have found it on manifest necessity. So Scout November Light said, bank holiday weekend here in the UK, maybe Auntie Bev is heading here. Maybe. And then we get the holiday in the US next weekend. Stephen, good to see you. Stephen said, sis, was consent in the room with us? You declared a mistrial and told the jury to get the fuck out. Miss you, EDB. Good to see you, Stephen. And I hear you and I get it. Thank you so much. Let's see. We'll see what the defense team said in their statement. Let's see. Thank you to our mods for grabbing it. Let's pull this up. This is from Boston 10. So we'll just pull this up real quick. Thank you guys for pulling local outlets. You know that it is always my preference to go to the locally local. Let's pull that up real quick. The judge definitely did say GFO in that case. Let's swoop real quick because there is a defense to Boston 10. Let's see. Come here. I'm like, come here, article. DA defense team respond to the ruling. The Norfolk District Attorney's Office, which is prosecuting the Reed case, released a statement Friday morning in response. We believe that the judge's decision is consistent with almost 200 years of case law. The statement said, we are moving forward to trying this case January 27th. Shocking. Reed's defense team also released a statement saying, quote, we respectfully but strongly disagree with the cornerstones of today's ruling and fully intend a vigorous appeal to assert and uphold Ms. Reed's Ms. Reed's rights founded on the foundation of the federal Constitution's double jeopardy clause. We could workshop this statement a little bit, but the defense vigorously disagrees. And when they say they disagree with the cornerstones, they believe that the court is fundamentally wrong the court's interpretation of the law. That is what they are saying. It'll be interesting to see what the Court of Appeals states. They are going to continue to argue the form over the substance over form argument, I think, is their stronger argument. The no consent argument is not their strongest argument. NBC Boston is reaching out to Reed's lawyers for comment on Friday's ruling. Well, it looks like they got it, and the article was updated with that, including with the full charge. And we can link, Miguelina, we can put the link to the article. If you guys want to read the entirety of the ruling that we went over yourselves, the dismissal is linked in Boston 10's article, and we'll link that down below for you. So the defense disagrees. Are we surprised? No, none of us are surprised. So they will be appealing. Shocking. And the judge knew that, right? Stephanie said, I am aware that it's an unseen situation, but I find it harsh that the silence of Karen Reed's equals her waiving a big right. Double jeopardy is no joke. So in the ruling, I'm going to try to explain this well, so hopefully it brings understanding. I'm not asking for agreement. I think there's room to disagree with Judge Bev's ruling. I get it. The understanding I want to hopefully illuminate is that with regard to the defense not objecting to the mistrial, the judge is arguing the defense acquiesced to the mistrial. I think that is not just taken as silence with regard to the double jeopardy. That argument only goes to whether or not the defense consented to a mistrial. It's a separate argument from the double jeopardy argument. The silence as to the double jeopardy argument is that the jury wasn't asked to be polled, and the defense did not ask for the jury to be polled. So I'm splitting that out a little bit because the defense consent to a mistrial is one part of the argument, but even if the defense didn't consent to the mistrial, there would still be manifest appropriateness. I forget the exact word that the court relied on, but it would still be appropriate to declare a mistrial given the 3 notes from the jury, given that they gave the Tui Rodriguez instruction, and given that the defense argued from the first note for the Tui Rodriguez instruction. So in that narrow circumstance of whether or not the defense consented to the mistrial, that is a very narrow ruling on a very limited topic, and one, again, that's not going to come up very often, except in a very unusual circumstance if the judge declares a mistrial like willy-nilly when the jury's not even indicating that they need it. Becca asked, has the defense requested a change of venue yet? If not, will Bev be in charge of the approval denial of that decision as well? The defense has not requested change of venue. I don't know if they will, but yes, that motion would go to the judge. Let's see. Stephanie, we got that question. Thank you. I'm here for ASMR EDB, the footnote voice. Happy Bird said, thank you for your always amazing coverage. You're welcome. Again, in this circumstance, I am hoping that we just have understanding. I know that we will not always have agreement, and it's okay. If we understand and disagree, I think that's fine. Trying to understand is important, even when we disagree. Look, as Rick Hogue says, reasonable minds can differ, and difference is what brings us to better understanding, right? If we are sitting here going, that jury instruction seems really weird, and the Judicial Council of Massachusetts is watching lawyers from all across the country go, so that's not how we do it in our jurisdiction, and that language is a little weird, and I can see where there's confusing, then maybe it changes and it gets better. And so I think that's where we try to reach the understanding, even if we disagree, and even where we disagree with the results, and maybe more importantly, to try to understand results you disagree with. It's easy to not seek understanding in the things you agree with. You're like, yeah, agree with that, done. But when you disagree, it can be really easy to say, I don't agree, and I don't even want to know how you came to that conclusion. I think it's harder to say, I don't agree, but explain to me why you came to that conclusion, because then we can find where there's room to fix it. And that's really what the law is. This is the law. This is the result. If this result doesn't seem to match this law, that's where new law gets made. And I realize that's a really simplistic way to express it, and that there's a much more complicated and multiple and varied process for that to happen. But that's essentially the heart of the law. This is the law, and then this result happened when the law was applied. Do we like this result? Yes, great. Do we not like that result? No. Does this need to change? And that's really the process of moving forward in changing the laws, whether it's through the Massachusetts legislature saying, hey, we hate that result, we're going to write different laws, or whether it's the court saying, hey, that's not what we meant, we need to reinterpret the law and change it through jurisprudence. Hopefully that makes sense. But I can understand where the court came to their ruling. I still fundamentally disagree on the court's interpretation of a juvenile standing for the proposition that you can never inquire with regard to a split verdict. But again, I don't practice in Massachusetts, and I may be wrong on that. It logically does not make sense to interpret that case that way to me, but I am not the judge. Kyle says, question, jury instructions written by counsel, does that apply to the forum as well? Yes, it does. In my opinion, Bev is in the bag, but I agree on dismissal. Recall the jury, though. I would like to hear from the jury, too. I was hoping to hear from the jury. And the verdict forms are all model verdict forms as well. Those are all done by model verdict form. If they are not done by model verdict form, the lawyers and the judge do them together. Kyle said, making homemade jerky sounds amazing. Jilly said, I don't understand why the jurors didn't say, wait, when she declared a mistrial. Why didn't someone say something? Jilly, they might not have thought that they could. So I don't know. Alana said, let's say the next jury comes to the same conclusion. If jury instructions stay the same, how do they avoid this from happening again? They can poll the jury. And the defense, I imagine, will be very vocal. That's a long way away, but the defense is going to be like, no, ask. Becca said, not only there for 10 weeks, but your decision is then undermined by the court's negligence. Why have a jury if their decision is insignificant? And Becca, I don't know if the court was negligent here. I think that the jury instruction is incredibly confusing, but those are the model jury instructions. I don't think the court read that jury instruction wrong. I think it's a bad instruction. But yes, incredibly frustrating for the jury. And I don't know how often this is the result in Massachusetts, which is why lawyers and judges in Massachusetts have these conversations, because other lawyers can say, you know what, this happened in one of my juries too. This was my experience too. Or they can say this case is a outlier and we don't need to change anything, but they're in the best position to know. So Jess said, I would love to see Em and Bev debate each other. It would be more of a conversation. I don't mind having a conversation with anyone that wants to have a conversation in good faith and try to come to understanding. I think the judge tried to explain in their ruling, there are things I don't agree with, but I think the judge went a long way in the ruling to try to explain how she came to the conclusions that she came to. She laid it out. This is why I did this way. And then we have the opportunity to say we don't agree, and we'll see what the appellate court says. I'm interested to see the defense's appeal. We're not going to stop covering it. I'm interested to see the defense's appeal and how they parse the court's ruling in that. Lisa said, how does a case become case law? Could the judge, in this case, do something to become new case law? As things go through the appellate court and as things go into jurisprudence, the case law, the record, the appellate court can change it. So when the appellate court says, hey, that case says this judge said this, we interpret it here, the here can become new law. But there's a lot of argument over if it's new law or if it's dicta. And this is why people go to law school, because whether a court has said it in a way that is a holding, whether the court has said it in a way that is dicta, really depends. Dicta means that it is essentially non-binding. The court is saying things. It's not binding. It's the jazz hands. The court's just saying it, but it's not part of the binding opinion that other courts then have to follow. So it really breaks down to that process of here is the law, here is the result, does this result need to change? And then the upper courts saying, yes, that results need to change. Let's have a conversation. And then if it becomes binding published opinions, then we move up the ladder, as you will. Chelsea D said, in my opinion, Bev doesn't understand continuing consent. Consent once does not equal consent later. That is a, Chell, I completely understand where you're coming from. It is a different context, and the case law in this context does not impact the case law in that context. They are completely different and separate contexts. So it is completely different. She is following the case law in the context of whether the very narrow context, did a defendant consent to a mistrial in their behavior in court when the court explained a mistrial. That is a very narrow context, and the case law on that was pretty clear, and the court cited it. And the court can't really do much with that because the case law is pretty clear. And if the trial court doesn't follow the case law, the appellate court is going to go, no. And if the trial court follows the case law, sometimes the appellate court is going to be like, yes, you followed the case law, but we're changing the case law. So very, very, very different contexts. Music to My Soul said, Judge, you keep using these citations about publicly affirming verdicts, but I don't think they mean what you think they mean. #inconceivable. KLV said, I feel like the end of court was just like mistrial by. It felt that way. It sure did. That the court was just like, yeah, okay, bye. It just was wild. Music to My Soul said, if they had asked the judge to pull the jury in the deliberation room after she had already declared a mistrial, would that have been legally different than questioning the jury now? If so, why? The court seemed to indicate the jury could be brought back in, but reining in a mistrial, I don't know if case law would have supported that either. I would have to look at the case law there because I don't know if once the mistrial is declared, if there's much you can do. But if the jury is all still in the room, here's where I can see an argument for the difference. The jury has not left the courthouse. The jury has not talked to their family members, friends, coworkers, intermediaries. They've not been on Twitter. They've not been on YouTube. They've not been exposed to things outside the trial. You haven't broken the seal of the jury, if it were. That's a really awkward turn of phrase, but you haven't released them into the wild yet. So there's less room for fuckery. There's less room for the jury's minds to have changed. So you might be able to fix it more quickly in time because they haven't been released into the wild. I still don't know what the law would do, but I think you would have to have the lawyers consenting. It would have caused a massive mess, but you would have to have the lawyers saying, you know what, no, the declaration of the mistrial was premature and the jurors did render verdicts, but it still would have caused a mess. But if it's an acquittal, there's not much that can be done with it because the prosecution can't appeal an acquittal. But if that had happened and it was a guilty, then the defense would have immediately appealed, and then it would have created even more massive. No, a mistrial was declared. You can't come back and find guilty verdicts. So it would have been difficult, but without the jurors being out into the wild, there might have been more that they could have done. But imagine they poll the jurors in a different case and they had come in with an acquittal, and then the judge polls them, and then they come in and are like, oh no, we had actually reached these guilty verdicts. The defense would have been like, absolutely not. Give us back that mistrial. We're going to try this again. We do not want those guilty verdicts. We do not consent. The mistrial's been declared. You can't go back and find them guilty. So it becomes a difficult situation, but you can't know which way the jury's leaning. And the defense wouldn't be arguing any of this if the jury reached out to the defense and said, by the way, we had guilty verdicts on these counts. The defense wouldn't have been making any of these motions at all, right? It's only coming up because of the potential for acquittal, of course. Let's see. We're going to get to a few more and then we're going to move on. John BeatyBot said faulty instructions were understood and followed. And I do think those instructions are confusing. Angela said, the fact that Demure and Eminem entered the chat is only one of the many reasons I love this community. Thanks, Emily. Yes. Demure, mindful, also love Eminem. Malin said, hi from Sweden. Been a rewatcher for a long time. Overjoyed to catch you live. What is the rough timeline on when we will hear from the appellate court on this? Oh, I don't know how long the Court of Appeals takes in Massachusetts. Months and months. Like, we are in the slowest of slow burns. Slowest of slow burns. Terry C said, Emily, important question. Can all of this come up in a new trial? No. Nothing that happened with the past jury comes up in a new trial. So, nope. All of this. Brit Focus said, I didn't know there was a ruling. It just happened today. That's why we ride. It's rare that we're just like, haha, we ride. But this one felt like we needed to ride. And then there's 2 or 3 days of Corey Richard's preliminary hearing next week. And then we've got Koberger stuff next week. So I'm like, when are we going to ride if we don't ride today? And so that was the, if not now, when decision that I made. So here we go. Here the fuck we go. Gertie said, I see how the court got there. I don't disagree, but this doesn't feel like justice. And Gertie, I agree with you. And that's the hardest thing when like the morality and the legality don't align. It just doesn't feel right. There's no process, but should be Commonwealth sense. Shame on them. And the Commonwealth has the opportunity to do the right thing. But I agree, it's frustrating. I feel you guys. And that is the difficult thing about law. And it's one of the hard things sometimes when lawyers come across as cold, and lawyers can come across as very cold, and very much like the law says this. And it's, you do a profession long enough, and there's times you forget sometimes when you're not talking to other lawyers and you're like, oh, that sounds really fucking harsh. Because it can be that cut and dry of like, well, that doesn't feel right. It's like, and the law says this. So I'm telling you reality under the law as it is. If you don't like the law, change it. But it can feel harsh because lawyers get very stuck in the legality without acknowledging the morality. And I think one of the things that I always try to do, and don't always do well, but very much try to do, is blend the two and acknowledge where things don't feel like they are aligned with how we want them to be. But it's also why I'm such an advocate for courts to be in the open, for public access to courts, because the only way we can see how we disagree with how the law results in things is if we know. How would we know, like as a collective humanity, that we disagree with the way the law handles a situation if we haven't really seen it play out? These things are theoretical until they're not. And I think we saw that most clearly in Utah, right? In the Ruby Franke case, where Utah is like, hey, this is the maximum on second degree child abuse. This is it. It doesn't matter if there's 1 victim, 10 victims, whatever. This is the maximum. 2 counts, 20 counts. This is it. And a lot of the law nerds in Utah reached out and were like, WTF? And even the attorneys in Utah were like, I don't like this result. And then you have legislatures in Utah going, I don't like this result. And guess what? They can change it. That's the law now. It doesn't mean it'll be the law going forward, and the law can change. But with so many people seeing that case and seeing the result, then you have people who know the question to ask, which is, why did this outcome happen? Because this statute says this. Okay, well, who wrote the statute? Them. Oh, okay. Well, then they can change it. So I think it's really important to have courts in the open, even when the results don't feel right, to see what the results are and what law they're relying on and figure out the why and understand the why, because then laws can change. Or you look at the law and go, you know what? I don't like the result, but the law is right. And Jody, who in the chat just said, we saw this in Baldwin too. Exactly. In Baldwin, you can look at the law and be like, you know what? I agree with the law. There needs to be some remedy when there is fuckery going on with police in the state. I don't like that it happened in Baldwin's case, but the law is right and the result is right. But I don't like that this result happened in this case, but the law doesn't need to change there. So it's tough when they don't feel aligned, and it's tough when it's like, this doesn't feel like the right result, but that's where change comes from. when you look at the law and you look at the result, and the result doesn't align. That's where there's change. So it's like the more you know, right? The more you know, the more we can have a conversation and the more we can continue to improve things as we see fit. The law changes slowly, but it does change. And I always approach it with maybe an overly optimistic approach sometimes, because even though it changes slowly, it still changes. Over Newbin said, question, judge says mistrial. I assume that is immediate record. If the poll comes after that, could that have been accountable decision since it was a mistrial after the mistrial was called? I think we talked about that pretty thoroughly. I would need to look at the law in Massachusetts, but I think there might have been a little bit of room there. Jess G said, I found this judge to be very unapproachable based on her attitude and huffing during trial. The jury might not have seen that, though. I wouldn't have felt comfortable with, hey, judge, we actually reached a verdict. That courtroom was really loud. And from the people in court that I talked to, there were a few reporters that I had talked to. It was very loud. Nobody perceived that other than us on the microphone where we heard it. So that's maybe different than what the jury perceived. Lori Porter said, won't the suspension of the investigating detectives hurt the prosecution's case? Yep. Can the defense use the FBI investigations if completed by then? It really depends on what happens, but possibly. Don't understand how the DA can move forward with this case. You and I are on the same page, Lori, and we're going to continue to watch. I don't know. Henhouse, good to see you, said howdy from the beach in Alabama. Thanks for the bonus ride. You are welcome. I hope the weather is beautiful and the water is clear. We have not been down to the beaches that way because we always end up over to the other coast, but it is on my list. Chloe Albert's Revenge said, I disagree. It came up because of potential for acquittal, but from the jury conviction voluntarily because they felt something was wrong. The defense brought it because of an acquittal, but I think that the jury brought it up, yes, because they felt it was wrong. Spock's Brainworm said, do you think public backlash will affect the way witnesses like the Albert testify in a new trial? I don't know. Maybe. Maybe. I think the place to direct the frustration is for the voters to direct the frustration at their elected officials. I think that's where frustration should go, because there is an outlet for change. Directing frustration at the DA in a non-threatening, strongly worded letter saying, I am a taxpayer of this state. Are you really going to spend, or of this county, are you really going to spend my money to retry this case? We saw it. What are we doing? Government has the room to make the decisions. The DA can choose not to. But there might be those that also say, there needs to be justice here, and this prosecution needs to move forward. So you never know how I feel like I was going to say you never know, but I feel like we kind of know how the residents feel, because we've seen a lot of residents coming in saying that they aren't thrilled with this particular prosecution. Shane. Good to see you, Shane. I don't know if I'm going to make it to the game tonight. I think I might show up to watch halftime by the fence line and then leave, because even though I don't think I'm contagious, I don't necessarily want to also be around all the humans, but I might scoop by just for halftime. It's good to see you. So I might scoop by and hang by the fence just for halftime tonight, because it is Friday, and that means it's Friday Night Lights for me. Well, maybe not, because I am just tired. So Adiba said, question, will there be a chance to scandalize the jury without Proctor, though? This is a great question. I mean, not the same way. I think that Alan Jackson wants his opportunity to say, see you next Tuesday in court more than once. This case would be so much cleaner if they just tried count 2, but it's not a clean case. You know how I feel. You guys know how I feel. Those prosecution experts were not good. We're not good at all. We're not good at all. So we'll see. Chat, it's good to see you. I hope I've answered your questions. I know there is lots of frustration. I hope there is some understanding of how the judge got here. This was not an unexpected result. This was the most likely outcome, always was the most likely outcome. The Court of Appeals might modify their process, might have a comment about whatever. The Judicial Council might modify their jury instructions so they're not quite so confusing. But I don't know if it will change the outcome here because the courts don't really have a vehicle to dismiss that power. And we have a separation of powers, or should. That power lies squarely in the hands of the executive branch, the prosecution, not the judicial branch, the judges. The judges can't at this point on these facts dismiss the case, because if there was a verdict, the judges, well, if there was a conviction, could they have overturned that and then ordered a new trial? Judges can do that. There's a lot of case law for that. That's what Murdaugh wants. But here they have a new trial. Once you're at new trial, there's not much the judges can do to forestall a new trial. And that result doesn't feel right. And the people to make it right at this point are the prosecutors. Will they do that? We will see. But it was good to see you on a Friday. We will see you next week. Cat Love Dreaming Peach said, do you know the current status of Proctor? There's an investigation. He is not being paid. He is relieved from duty. So he's on the slower road to getting fired because of process. I will be keeping you up to date in the app about when we will be streaming next week. There is lots and lots of rumbling that the court does not want the case in Corey Richins to be streamed. In fact, the media order specifically says no streaming. So as I figure out how and when I will be covering that, I will let you know. I've been working with the pool camera to try to figure that out for us. But the court has very much said no streaming, which means that there is not much we can do, because even though there will be audio coverage of the proceedings, that can't be streamed either. So I will keep you in the loop on what we're doing with Corey Richins. Make sure that you have the Law Nerd app, and that's where I can keep you in the loop the fastest. Have a good weekend. I am going to be resting. I will see you later. Lisa said even on Court TV, yeah, no streaming, period. There will be video after the fact. So I will keep you up to date on that. Get the Law Nerd app. It is the best way for me to tell you what's going on day to day, and it's the place where I am the most frequent. And with that, have a good rest of your Friday. Have a good weekend. Take care of yourselves, and I will see you next week. Bye, guys. You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com, or search the App Store for Law Nerd. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday, for when you just have time for the quick bits. Thanks for being a Law Nerd.